October 12, 2023 Board of Adjustment meeting to order. Madam Clerk, would you please call the roll?
Kathy Bontemps,
Here.
Stephen Craddock,
Present.
Robin Kane,
Here.
Sam Miller,
Here.
Troy Breathwaite,
Present.
Shay Balance, Justin Hayslett.
Looks like we have a quorum, have been met with 5 regular members and 1 alternate member present. Are there any changes to the agenda for tonight? Hearing none, could I get a motion to accept the agenda?
I'll make a motion to accept the agenda as written.
Second.
All in favor, say aye.
Aye.
All opposed, nay. The motion carries unanimously. Are there any changes to the minutes from March 9th, 2023?
I don't have any.
Hearing none, may I have a motion to accept the minutes as written?
I'll make the motion.
I'll second the motion. All those in favor say aye.
Aye.
All opposed, nay. Motion carries unanimously. In accordance with the State Government Ethics Acts, it is the duty of every board member to avoid conflicts of interest. Does any board member have any known conflict of interest with respect to any matters coming to the board tonight? If so, please identify the conflict and refrain from any participation in the particular matter involved.
No, sir.
I don't have any conflict, but I do want to make note that I recognize a Mike Barr. I believe Mike may be presenting. Mike's firm, Bissell Professional Group, that he's a surveyor for, has done work for my company in the past. So just a acknowledgement of the relationship. I don't personally see a conflict, but if someone else does or would mention that, I'd be definitely welcome to listen to it.
Is there anything about your working relationship, or, I mean, he's certainly a well-known engineer in our area. Is there anything about that would cause you not to be able to sit fair and impartial, or
No,
hear
not
the
at all.
evidence as presented?
We have a very good professional relationship, no issues in that respect. The firm has always done good work, and I hold Mike and his team in high regard for the work that they do.
Okay.
So I trust them.
All right, but anything about that would make you sway more in his direction versus the county's direction, or anything like that, or can you keep an open mind?
I think I keep an open mind. I think it's basically a fact-based piece from that.
All right. Does the county want to be heard?
No, I have no objection.
Okay. All right.
I'd like to make a motion that we accept Sam Miller's explanation and let him remain on the board tonight.
A second.
Any discussion? All those in favor say aye.
Aye.
All opposed say nay. Motion carries unanimously. If there's anyone in the audience tonight wishing to speak on any item on the agenda tonight who's not the applicant, please sign in to speak if you have not already done so. Is there any old business tonight? Hearing none, we'll move on to new business. New business is motion to dismiss Board of Adjustment 23-03 Murphy Delaney application for a variance.
Thank you, Mr. Chairman. I believe you've received a motion to dismiss in advance. I know this is not very common, so it might look kind of funny, but needless to say, this is the county's motion to dismiss this variance application. The Unified Development Ordinance contains standards, some review standards, 6 that have to be found, all of which have to be found in order to grant a variance. It also contains a provision that contains what cannot be grounds for a variance, such as the fact that land or a structure may be utilized more profitably or be more marketable with a variance, as well as financial hardship. So if those are found, that those are not grounds for a variance, and that's the basis for my motion. If you look at the variance application on its face, the hardship appears to be financial, and with a variance, the property is more marketable. And I base that on the narrative in the application that states the applicant tried to, they wanted to seek a return on their investment by selling this lot. And only then, when the purchaser backed out of the deal, they realized this lot was not buildable. Nowhere do I see they want to develop it themselves. It seems to me as if they want to just sell it and seek a return on their investment, which clearly is a financial hardship. Also, it's showing that the property would be more marketable, that they can sell it with a variance. Therefore, the county moves to dismiss the application.
Are there any questions from the board members to council?
Yeah, I do have a question. There are clear items that cannot be considered for a variance, and that is very well understood. My question is, if those items exist along with the other 6 criteria for a variance. So if the 6 criteria for a variance can be met, there may be circumstances that appear to say otherwise. But if the applicant is able to demonstrate to the satisfaction of this board that they meet all 6, even though they may have another motive as well, how does that get addressed in terms of the dismissal?
Right. I think that's a great question. I mean, really, I think you would have to hear the evidence from the applicant, and then I can renew my motion at the end of the evidence once you've heard all of that. And so I definitely understand if that's what you want to do. We just have the application before us. We haven't heard testimony, seen their exhibits and whatnot. So there could be other grounds. This is just based on the application itself. I didn't see any other hardship other than a financial.
Okay.
So you'll need to give the applicant an opportunity to respond to her motion as well. So, but if you did have more questions for her, but he might answer some of those questions. But
All right. Was there any other questions for the board for council?
No.
Okay. Give the opportunity to the opposing counsel to respond to that.
Unfortunately, I have a lot of things that can be dealt with in response here. But to answer Mr. Braithwaite's question, let me initially say that this is a motion to dismiss that is an attempt to make it so you don't get to hear the merits, you don't get to hear our evidence. And we first think that that doesn't meet your procedural rules in your ordinance. One, the way it is, you file an application, the planning director can tell you that it's incomplete, he has 10 days to do that, and if you get past that 10 days and he doesn't tell you it's incomplete, you're entitled to an evidentiary hearing under the general statutes and under the UDO. The only time where you would have a motion to dismiss that would be valid would be if it's a subject matter jurisdiction question, in that it's not an evidentiary question. It's not a question of what goes into the filing. That might be something you would see in a superior court with what's called a 12B6 motion, where you have to plead a complaint and you have to put in your elements and stuff, but that's not what you have to do for a variance. For a variance, you just have to make the application, and you get to come in here and have an opportunity to put people under oath and be heard on it. With regard to Ms. Morgan's motion in particular, let me point out a couple of things that are important before I get back to Mr. Braithwaite's question. In paragraphs 7, 8, and 9 of her motion, she underlines a couple of different places where it says rendered, in 7 it says rendered lot E valueless, but she forgets the first part of the paragraph where it says, when the Board of Adjustment, following along with the county, determined that the lot was unbuildable for any purpose, it rendered the lot valueless.
well, To be clear, though, the board found it not to be a lot of record, so,
They found it was unbuildable,
they determined it was not a lot of record.
but they determined it was unbuildable. The unbuildable's in the order, isn't it?
I don't know, I'm just saying, and I don't want to get lost in the weeds in the motion to dismiss, because, but anyway, keep going, I'm just saying, I don't want to get lost in the weeds about arguing over the things you want to argue in the motion, so I think that to the board, you know, if the county's motion is kind of, I kind of reviewed it like as a motion for summary judgment, if you will.
Which you can't have in this case.
I'm not arguing with you, I'm trying to explain that I reviewed this kind of as a motion for summary judgment, which is, if that is she viewed that as the only basis in the application, your contention clearly is that that's not the only basis in the application.
And it's, yeah, our contention is, not only is it not the only basis, it's just an effect of the cause of the only basis, which is the determination that nothing can be built on this lot. But let me start with a case called Churich v. Surf City before I get into the more details of the history of variances. May I approach Mr.
You
Chair?
may.
And I'll just say, in the interest of efficiency, I mean, we can go ahead with evidentiary hearing, because it looks like he's got quite a bit of cases.
But I was going to suggest something to that.
That's
If,
fine with me,
okay.
yes, no objection.
Do you just want to withdraw your motion, or do you want
Yes, when I see all these cases, I don't think
to? Okay. I was just going to say,
less time to
You
do
know.
go through the hearing.
yeah.
Hey, Ben, the clerk and I need one. You gotta give me yours, you gotta go by memory, I'm just joking. It's fine. It's fine, I'll work. If she's withdrawn her motion, is this even necessary at this time, Ben?
Not at this time, no.
Okay, so can,
be useful later.
okay, so you guys can just set this aside for now,
Okay.
and then let's let.
Well, first I have a question. When it comes to the legal aspect of the motion to dismiss itself, does it have the legal standing to be effective as that?
As a motion to dismiss? So I don't know that, I'm sure Mr. Gallup argues that, you by default are permitted to have the hearing, no matter what the status of the application is, if you make it past that 10-day. I didn't research that, but in light of the fact that she's withdrawing her motion, it's irrelevant because it's not before you at this point. So rather than spend time arguing over whether we can have a motion to dismiss, if the county's ready to proceed on the facts of this application, then we can just get into the meat and move on, so.
Excellent.
Then that this is a new application, correct?
This is a new
Yes.
application
For
for
a
a variance.
Variance.
Right, but we heard this case in another,
Correct.
Format.
And that case is still on appeal.
right?
All right, so at this time, the board, would you like to make a motion to accept a withdrawal of, or a motion to dismiss?
Yeah, I'll make a motion for the board to accept the county's motion to withdraw the dismissal.
I'll second.
Any discussion? All those in favor say aye.
Aye.
All opposed say nay. Motion carries unanimously. Next item up, BOA 23-03 Murphy Delaney variance request. Tara Murphy and Edward Delaney are requesting a variance to Section 10.5 definitions of the Unified Development Ordinance as it relates to the definition of existing lot of record, concerning their property at Lot E of the Seagull subdivision, Tax Map 101C, Parcel E, Fruitville Beach Township. All those who wish to speak on this particular matter need to be sworn in. If you'll raise your right hand and put your left hand on the Bible. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Ready for staff to start the case?
Thank you, Mr. Chairman. I call Kevin Kemp as my first witness. Scoot over so I can see. Can you state your name and how you are employed?
My name is Kevin Kemp. I am the Development Services Director for Currituck County.
And what is your educational background?
I have a master's degree in architecture from the University of Michigan and a bachelor's of science in industrial design from James Madison University.
Prior to your employment with Currituck County, what has been your employment experience?
I worked with the City of Virginia Beach for 10 years as a zoning inspector, a planner, and then the last 5 years as the city's zoning administrator.
And what were your duties and responsibilities in those positions?
I enforced and interpreted the city's zoning ordinance. I managed the zoning division, which consisted of 20 people. I made professional recommendations and provided technical support to city leadership, and I represented the city on legal matters regarding zoning and planning issues.
And in your current role as director, what are your duties and responsibilities?
I enforce and interpret the Unified Development Ordinance for the county. I manage the Development Services Department, which consists of planning, code enforcement, zoning, and permits and inspections, 24 employees in all. And I provide determinations for things that are not necessarily clear in the UDO and represent the county on legal matters.
Are you familiar with the matter before the board tonight?
Yes, I am.
Can you briefly describe how this matter got before the board tonight?
The matter originally came in the form of a request for a determination from the applicant. This came in March 4th of 2022. The request came into the county manager's office, who then relayed it to the Development Services Department. Then on March 12th, I composed a determination letter. Now, the nature of the request was as to the buildability of the lot. The determination letter was sent, which noted that the lot was not a buildable lot. The determination was then appealed to this board. This board considered it on July 14th, 2022, upheld my decision. It was then appealed to the Currituck County Superior Court. I believe the case is still active. And then this application was recently filed for a variance, and it's in front of the board tonight.
May I approach the witness?
You may.
Was that decision that you just mentioned from this board, was that reduced to writing?
Yes, it was.
And is that what's in front of you?
Yes, it is.
Okay, I move to introduce the order of this board in the prior matter into evidence.
You may proceed.
Are you accepting it as County
Yes.
1?
You may proceed.
What type of application is before the board tonight?
It is a variance application.
And what exactly is the application requesting a variance from?
The variance would be to the definition of existing lot of record.
May I approach the witness?
You may.
Thank you.
What is this document?
This is a page taken out of Chapter 10.5 of the Unified Development Ordinance.
And does this contain the definition of existing lot of record?
Yes, it does.
Would this assist with your testimony tonight?
Yes, it will.
Okay, I move to introduce this definition of existing lot of record into evidence as County Exhibit 2.
Okay, we'll accept that. Proceed.
Okay, and I think I cut you off earlier. What were you saying when you said they were requesting a variance from this definition?
Correct. The determination was made based on this definition that it wasn't a buildable lot. What this variance would do is it would be a variance from that definition, which would then allow the applicant to pursue whatever permits and steps are necessary to develop the lot.
Do you have a recommendation for the board tonight regarding the variance application?
Yes, I do.
And is that recommendation based on your education, employment, experience, and training?
Yes, it is.
Okay. Let's see. May I approach the witness?
Yes, you may.
They're folded up, sorry, they're kind of large. And these were mainly what was on the PowerPoint tonight, I believe, so you have them in front of you. I just passed you two large documents. What are those?
The two documents, the first is the preliminary plat for the Seagull subdivision, and the second one is the final plat for the Seagull subdivision.
Oh, I'm sorry.
Could you clarify which one is preliminary and which is final?
Yes, can you clarify, Mr. Kemp, which one is the preliminary and which one is the final?
As far as color goes, the white one is the final plat. The kind of beige color is the preliminary. In the bottom right-hand corner, the preliminary in small letters does say preliminary, and it has a kind of chart of land use above it. That's the best way to distinguish.
Mark, the preliminary is County 3 and the final is County 4, just for everyone's tracking purposes.
All right. We'll accept both of those exhibits.
On each of these plats is Lot E, which is the subject of this application. Is it depicted on these plats?
Yes, it is.
Okay, and let's just choose the final plat. So in using this plat, can you give the board a very brief overview, since it was already heard and decided, how staff came to the determination that Lot E did not meet that definition of existing lot of record?
Okay, what staff did was we took the definition that you have in front of you of existing lot of record, and we broke it out piece by piece and analyzed the lot based on each one. The first criteria is that it's part of an approved subdivision, so we looked at that, and the lot is part of the Seagull subdivision, but on both the preliminary and final plats, it does note that there are lots 1 through 33. Staff determined those 1 through 33 as the buildable lots. The lots that were not buildable and more open space were the lettered lots, and there were 6 of those, A through F. There was a letter we found in the file that noted possible reasons those were unbuildable. There were.
I think the letter's here, so there isn't any evidence that the letter has ever been part of what my client considered.
I believe it was mentioned in the letter determination that was affirmed by the board, but I don't, I guess I don't even know what the letter, where the letter, who wrote the letter, where the letter came from, so maybe
We,
clarify that. I know she said give us a brief because it was already decided, but, anyway.
And I don't think he's using that letter to prove the truth of the matter asserted. I think he's using it to just show how staff came to their determination that Lot E was not an existing lot of record.
and that's fine. It was just determined by staff that those lots were unbuildable for one of three reasons. It would be that they did not meet the dimensional requirements in place at the time, that the soils were unsuitable for septic, or that there wasn't adequate access. We further looked then at the preliminary plat, and there was that chart I mentioned in the bottom right-hand corner that mentions land use. It had the total acreage of the lots. It then broke out to another category, which was acreage in parks and other land usage, and that was 4.879 acres. So we took the lettered lots, added them up, and it equaled that total. So that, again, further asserted that they were intended to be parks or other land uses.
And what is the next part of that definition of existing lot of record, and how does it pertain to Lot E?
It's that the lot is described by meets and bounds, and that it meets all the zoning and subdivision regulations at the time. Staff determined that it was not described in meets and bounds, and it did not meet the dimensional standards at the time this subdivision was recorded.
And regarding the remaining parts of that definition, how do those pertain to Lot E?
Two other things considered from the definition. One is for it to be a legal lot if it was platted before August 2nd, 1965, which this lot was not. And then lastly, if there was an existing structure on it that was permitted, and this lot is undeveloped, so that was not the case. And that is what we used to determine the lot was not an existing lot.
And ultimately, did this board agree with staff's determination that Lot E did not meet that definition of existing lot of record?
Yes, they did.
Okay. Now let's talk about the specific variance review standards, as that is the application before the board tonight. Are those standards specifically listed in the Unified Development Ordinance?
Yes, section 2.4.14D lists the 6 review standards for a variance.
And are all of those standards required to be met in order for a variance to be approved?
Yes, they are.
Okay. What is the first review standard, and how does that relate to Lot E?
The first review standard is that the hardship is suffered by the applicant because of this ordinance. In this case, the lot is not meeting the definition of existing lot of record, which is a part of that ordinance. As such, it cannot be recorded, and the permitting and development process cannot be done through the county.
What is the second variance review standard, and how does that relate to Lot E?
That the variance relates to the land, location, size, or topography rather than personal circumstances. And in this case, staff did look at the lot. The lot is irregular in shape. As you're aware, it's shaped like a elongated triangle where the depth far exceeds the width. So it does relate to the lot dimensions.
And what is the third variance review standard, and how does that relate to Lot E?
The third is that it is unique. Staff looked at this. Although the shape is unique, there are 5 other lettered lots that are mentioned on the plats. So it is not unique in the fact that it was platted as, an open space or other land use.
Okay. And what is the fourth variance review standard, and how does that relate to Lot E?
The fourth is that it's not a result of the applicant's own actions. There is nothing developed on this lot. The applicants purchased the lot in 2003, and to staff's knowledge, nothing has changed since 2003 in regards to it being a buildable lot.
What is the fifth variance review standard, and how does that relate to Lot E?
The fifth is that it would not authorize the initiation of a nonconforming use. This property is not developed, therefore there is no use on the property, therefore no nonconforming use. The application does note that the property, the desire is to sell the property for development with a single-family home. The property is zoned SFR, and single-family homes are a permitted use in that zoning district.
Does the application indicate that the applicant is going to develop build a single-family home on the lot?
The application doesn't say that the applicant is per se. It mentions that the desire of the lot is to be developed with a single home. The application, I believe, speaks as to the sale of a lot with the intention of it being developed with a single-family home.
Okay. And what is the sixth and final variance review standard, and how does that relate to Lot E?
The sixth is that is consistent with the spirit, purpose, and intent of this ordinance. Staff looked at two things here. The first is Section 1.3, which lists 16 general purposes and intents of the UDO as a whole. Not all these applied to this lot, but a few did. The first was, that it's compatible and efficient relationship amongst other land uses. Single-family use, which is, what the desire of this lot is compatible with surrounding uses. However, staff does note that it was platted as open space and, for that development. The second was to better manage or lessen congestion in the streets. Although it's only one home and, the impact would be minor, it would add traffic onto the streets of the neighborhood, which in the off-road area are unimproved. The third is adequate open space between uses. Again, this was platted as open space in 1974 when the subdivision was recorded. And the last is to prevent overcrowding. Again, the impact would be minimal in staff's opinion, but it does add a dwelling unit or buildable lot to the subdivision. The second thing the staff looked at was the district purpose for the SFR district, and just notes that the district is intended to accommodate limited amounts of development, preserve natural resources, and recognizes the inherent limitations on development due to lack of infrastructure. I thought that applied, and that's what staff reviewed for the sixth standard.
Okay, and does the Unified Development Ordinance have a section that contains grounds that cannot be used to receive a variance?
Yes, it does.
And what section is that?
That is section 2.4.14E.
Did staff find that any of those grounds that were not sufficient for a variance applicable for this subject lot?
Overruled.
Well, he just testified about the other six standards, so I think he can give an opinion about whether he felt, based on his review, that was that, but ultimately that determination is the board's to make. Just like the other six grounds he just testified to are the determination for the board. Well, he already overruled it, and I think he can testify about that.
Staff reviewed those standards, those five standards, and found that the third one, the land or structure may be used for profitability or to increase marketability, and the fifth one, financial, those do relate to this application based on the narrative that was submitted with the application.
And what is staff's recommendation to the board tonight regarding this application?
Staff recommended denial.
Okay. No further questions?
Thank you.
Any questions from the board to Mr. Kemp?
I have one, or two. So the staff recommends denial based on which of the six criteria?
Staff would question the uniqueness of the situation in that it is one of six lots that were platted as open space in this neighborhood, and staff would argue that it is not consistent with the spirit and intent and all things that were encompassed in that.
So is that the only one of the six that?
Staff also feels that as far as, it's a result of the applicant's own actions, although no development has been taken place on the property, it was purchased by the applicant, and nothing has changed since that point of purpose, meaning that, at the time of purchase, staff would hold that it wasn't a buildable lot as it remains there today.
And then you said this subdivision was platted in 1974?
Yes, September 2nd, 1974.
And And at that time, was there a development ordinance enforced in Currituck County that required open space for subdivisions?
It was the 1971 ordinance. I am not sure, I could attest to the requirement for open space. We have a copy of the ordinance over there, if you would like her to look further. What we looked at when we reviewed the plat was the dimensional standards, the lot size, lot width, and lot depth.
Yeah, I mean, looking at the subdivision, the final plat here, I mean, it looks pretty clear that that lot at that time was not intended to be a buildable lot. I mean, you can see the setbacks on the other lots and all the ones that are intended. But I think my question kind of gets to the fact that it was not, the fact that it was recorded as open space at that time, if that was not a requirement at that time, does that relegate that lot to
Right.
that status forever?
Right, and in my research, we have looked at the fact that it was recorded as such, but in my research, I will say I have not found a requirement that said a certain amount of open space is required. I think the open space that, is pictured here is because it was platted on that original plat as, I think the preliminary called it as parks or other land use. But I have not, in my research, found that there was a requirement of open space to which this was charged towards meeting.
The other lots, have any of them been the ones that were platted as open space? At least one of them has been developed.
Yes, that is correct.
Not unheard of to take the open space and then develop it.
Correct, that has been done. There might be two that have been developed.
Yeah, I think I've
I think one was the access change where it was then provided access, something was done there. The other was a recombination.
Okay.
So yes, some of the lettered lots have been developed since this was recorded in 1974.
So when you say they were developed and subsequently permitted to become a lot of record,
Yes.
in those cases, was there something that was required to be done for that to happen? Or did that just come up of somebody said, hey, I've got this lot, I'd like to do something with it, do you mind if I build something on it?
There was something done in both cases. As I said, in one case, the access was changed, so then the access, the lot had access.
Okay.
Whether it was easement, I'm sorry, I don't have it in front of me. And then the other was a recombination, which allowed that lot to meet the standards and be developed.
I know Lot
Thank
D has a home on it. And I don't know whether it was recombinated or not, but
So
I
at
saw
the
that
last
online.
hearing, and I know it's kind of hard because we heard a lot of evidence at the last hearing, but one of the things that was discussed were what happened with those other lots, and there was one lettered lot that was, there was a recombination and then construction on that lot.
Okay.
Now, do I know that, can I recall as I sit here in front of you and tell you that it was B, or that B was the one with access? Okay, but anyway, right, he said there were two. But the one, I do recall that there was one with a house that had been, there was a recombination that was testified to last time.
Okay.
Any other question from Mr. Kemp?
So what would be the impact of further subdividing this lot?
Well, he's not asking for a subdivision.
Right, but I'm asking if that were to occur, what would that impact be? Say, for example, that narrow part on the end, if it were subdivided out of the property, does that reconstitute a new parcel?
It would, I think the difficulty would be that any kind of subdivision of the parcel we would need to look at today's dimensional standards and creating a lot in today's ordinance requires 120,000 square feet.
And I guess I have a question because, and this is a little unusual because I normally don't ask questions because the board's asking questions, but the board has already previously determined that this is not a lot of record. So can you explain what exactly this variance, I mean, how do you understand this variance? I mean, what is the request? Is the request to have the board vary from the decision they already made? Or change the dimensions? Can you explain what exactly, I mean, you said they're asking to vary from the definition, and how? Because the board's already made a decision, and so what is this variance asking? If you could tell them.
What this variance
That you
is
understand.
asking, when you're asking for a variance to the definition, so staff has determined that it does not meet that definition of existing lot of record. And because it does not meet that definition, when they come in and try to pull a permit, that is something we check and we will not move forward with that process. By getting a variance to that definition, then we would not essentially just not consider that definition that it you know, and move forward with the permitting. So a variance saying, you know, to that definition, where that definition is not considered in moving forward.
So then.
It's a tough concept to explain.
Right, so your staff's understanding of this variance request is that the applicant's asking to skip over the definition of lot of record and just move forward with permitting under the development standards in the ordinance today?
Well, the development standards of the ordinance today, I'm not sure on moving forward. I mean, if they're skipping over that definition, then, you know, they're not recording a lot to today's standards, which I mentioned, you know, are 120,000 square feet. However, they would have to develop to the setback standards, lot coverage, and those sorts.
So I guess that takes me back to my original question, which is they're asking the board to vary from the definition that they already determined?
Or is it a waiver from the application of that definition?
That's how I view it. That's a more elegant way to put it.
I guess the only thing I can do is object to the question so I can have a say here. The application includes what we're asking for, and it's not just a change necessarily to the lot of record. It's a change consistent with the plat that's attached. Whatever changes are necessary, whether it's to the lot of record or to the setback rules or to the measurement of depth, you have to go back and consider the concept that we're already at the point where the county and the board have determined it's not buildable. So we're trying to vary the ordinance provisions that make it not buildable. But part of that not buildable looked back at the 1971 ordinance when it did that. So I've asked to vary a number of different possible things. But the hard part for us in asking to vary it, and the reason why we provided a plat, was because we don't agree necessarily, and part of why we're on appeal is because we don't necessarily agree with the decision that the board made. And I don't want to get into that tonight because that's where we are. We're assuming that you were right, but it's tough for me to tell you exactly what varied when I don't necessarily know exactly how you got there. So I've asked to vary a number of different possible things, and if any of them are varied in accordance with the plat that we provided, we want to be able to build within the building envelope of the plat that was attached to the variance, which it could be a variance of lot depth, or where you measure the minimum building line under the 1971 ordinance. It could be a number of different ways to vary it, but what we're asking is whatever of those it takes to make it so that we can use the plat that's provided and use that building envelope to potentially build a single-family residence on. That's all we're asking for.
So you're asking the board to grant kind of a blanket variance to whatever section in the UDO that permits the plat that you've attached here. I'm just trying to understand the variance that were. Okay.
There are a number of sections in the UDO and in the 1971 zoning and subdivision ordinances, any of which you could vary potentially and get to the same result.
And I would argue, I don't think the board is tasked with deciding which provisions to vary. I think it's the applicant's
I don't want to
responsibility.
get in an argument. My question was based on what is staff's making a presentation about the application and what the applicant is asking for, and we can get to argument later. But my job is to make sure the board knows the issue that's before them, and this case has been here before, so that's why I was asking those questions, and certainly you can come back to your,
I assume we're gonna have argument at the
So-
end, and
yeah, no, absolutely.
Excuse me for a minute, if I may, I think I'd like to see if we could maybe proceed, Mr. Chairman, how we are hearing this out. I looked at your application, Mr. Gallup, and to her point, I really struggle with what is it that you want to vary? I mean, my
Well, he's gonna
perspective,
put on his
my perspective,
presentation.
and I get that, and I don't, this is a rhetorical question, more or less. We'll hear from you what that is, but in my opinion, and how this board functions and the way that I function is you ask for a variance of the board. We'd like to vary X. Will you accept this variance because of this situation? That's what I'd like to hear from you. What do you want to vary? And if it's just vary everything, that's going to be a struggle, I think.
definitely not very early.
Okay, so
It's very,
I'm looking forward to hearing from you about that, but I think that's kind of where we'd like to get to at this point.
Oh.
Is
Okay,
that-
so
do you guys agree?
I'm sorry to cut off the board if the board had any other questions. I just wanted to know from staff, and then certainly the applicant will have an opportunity to address what exactly they're requesting.
All right, we can get back on track now. Are there any other questions for him from the board members? Okay. About opposing counsel, do you have any questions for him?
There's a
Green light?
okay, there we go. Good morning, or afternoon, Mr. Kemp, how are you?
Good.
Doing well, I hope.
I am.
Basically, under your decision and under the Board of Adjustment order that was entered in the appeal, nothing can be built on this lot, is that correct?
Correct.
Okay, so the only use for this lot is to be vacant land?
Correct.
And this isn't a situation where on this lot, the owners could build a home, but they're asking for a variance to be able to build a more intense use, a gas station or a more valuable use, is that correct?
No, sir.
The only thing they're asking to do is to build a residence, be able to build a residence on what now is stuck being a vacant lot.
Correct. As I understand it, the intent is for a single-family home.
Yep, so they can't build anything, correct?
It was ruled not a buildable lot.
No buildings of any kind, no sheds, no structure of any sort.
Yes, they could not move forward in the permitting process if it's not a buildable lot.
Okay. And so let me go through, you prepared a staff report, correct?
I did.
All right, and you're aware that under the ordinance, you've got to prepare a staff report, is that correct?
That is correct.
And it's got to include all of your findings and all of your information, how you're developing your decision, is that correct?
Correct.
Okay. And you have to include a recommendation.
Correct.
And can you show me in your staff report where you mentioned anything about the economic analysis that you provided to Ms. Morgan a little earlier?
Which economic analysis are you?
She asked you about the provisions of the variance,
Oh,
the things you can't do.
that is not in the staff report.
And are you aware that the ordinance provides that the staff report needs to be provided to applicants and the board in a reasonable time?
Yes, sir.
Are you aware when it was provided to me?
Not directly, no. Not specifically,
Okay.
I believe, earlier this week.
You aware that it was provided yesterday?
I was not aware, I just knew it was earlier in this week.
Okay. And let's go through, so variance has 6 standards under the UDO, is that correct?
Correct.
Okay, and you're not challenging that the applicant meets the first standard, which is that the hardship suffered by the applicant is because of the ordinance?
No, sir.
Okay. And you're not challenging that the applicant's land is it relates to the land, the variance relates to the land such as size, location, shape, topography, those sort of things.
Correct.
Okay. And you're not challenging that it's creating if the variance was granted, allowing a residential use would create a non-conforming use in the district?
Correct.
And you've already stated that there are other lots that were similarly labeled on the final plat with letters rather than numbers
Yes, sir.
that were built upon.
Yes, sir.
And are you aware, in your job as a planner, planning director, you're aware of the North Carolina general statutes, right?
Yes, sir.
You've had a lot to do. How long have you been here?
I've been here just over 2 years.
So right in the heart of 160D updates, right?
Yes, sir.
So you're real familiar with 160D.
I'm familiar with it. I could not spout all. I have not memorized it.
And 160, do you recall that maybe 160D, 705D is the provision about variances? Have you ever seen where it lists the standards for variances?
I don't have that in front of me, so I know that standard is in there. However, I don't have it in front of me.
Okay. Well, let me ask you about one particular part of that standard before I even show it to you, because you might be aware of it already. But are you aware that the standard that relates to actions taken by the applicant or property owner, that in the general statutes, it says the act of purchasing property with knowledge that circumstances exist that may justify the granting of a variance is not a self-created hardship? Are you aware of that provision?
If it says it in there, then it is in there.
So your statement about that they purchased it as a buildable lot, and you didn't even say whether they knew or not knew.
Correct.
The statute, if it says what I just read to you, then that wouldn't apply either. Is that correct?
Well, I just stated when they purchased it and that, in 2003, and that nothing has changed since then. But
Then I'll read it to you again. It says the act of purchasing property with knowledge that circumstances exist that may justify the granting of a variance is not a self-created hardship.
correct.
So,
Yes.
so even if they knew about it at the time, that provision, since nothing's changed, they haven't actually physically done anything to create the variance calls, right?
Correct.
Okay.
Yes.
All right, so when we get down to the last one, the spirit and purpose and intent of the ordinance such that public safety is secured and substantial justice is achieved. Let me see. Next to Lot E, the lot we're talking about, just to the east of that, there's a 60-foot right-of-way, right?
Yes, that is correct.
And just on the other side of that, there's a row of houses
Correct.
and another row of houses.
Correct.
And there's more houses to the north.
Correct.
And that 60-foot right-of-way can be used to access the houses that are existing there for fire, EMS, law enforcement, right?
Correct.
And it can be used to access the other houses that are north of there and south of there for fire, EMS, and law enforcement, right?
Correct.
And in fact, this lot abuts or is next to a volunteer fire department-owned piece of property.
I'm not sure the direct vicinity of it, but yes, there is volunteer fire department property in that area.
And it doesn't have a fire station or anything on it, right? It's just open land, isn't it?
I'm not sure.
Okay. Are there other houses being constructed, single-family houses in the SFR district?
Yes, sir.
So people can still construct those.
Yes, sir.
So every time somebody constructs those, they have however many people that are using them that might need public safety services. Is that correct?
Yes, sir.
And if this property was developed with a single-family residence, it wouldn't be any different in that regard than any other house that might be developed north or south or east or west of that property.
Right, you are correct.
Is there anything else that you can show that there's a public safety issue with developing this property as a residential use?
No, sir.
Okay. You talked a little bit about the two plats that we looked at. We looked at what you call the preliminary plat. Now, preliminary plat can mean a couple of different things, right? It can mean a literally preliminary plat, and then it can mean an ordinance preliminary plat, right? One that comes and gets filed and somebody applied for it and then goes through some process, right?
Right, the preliminary plat would go through a review and approval process.
And, isn't it normal for a preliminary plat that goes through the review and approval process to have a stamp on it somewhere that it's been approved as a preliminary plat?
Yes, if one were recorded today, it would require that certification.
And you don't record preliminary plats, right? You only record final plats.
Yes, I believe that's correct.
Okay, but you come and get approval of a preliminary plat, and then staff would stamp it, and then the developer would go out and do the infrastructure, and then come back for the final plat, right?
The preliminary plat is a step in the process. Yes, it goes through that first round of approvals to then, once you have that approval, then you can move forward to construction drawings and moving along in the construction process.
Do developers ever bring you a plat that isn't part of an application? They'll let you look at it and it stays in the file?
Possibly.
Okay. And in this case, can you tell from the face of this plat, other than the word preliminary, which is not something that the county put on there, that's part of the surveyor's part of the plat, right?
Correct.
So can you tell from anywhere on the plat that this was a plat, that was a preliminary plat that was approved by the, by whatever body would have approved it at the
So
time?
I don't want to relitigate things that were litigated before, so can you point us to how that's relevant to the variance?
Sure. He says that he knows the intent of this subdivision, and he wasn't there, and it's not on the face of the plat what the intent was, and I'm pointing out to the board that his testimony of what he thinks the intent was is not consistent with what the plat showed.
The intent as it relates to what ground in the variance?
The last one, he says, development of the lot, the single-family dwelling consistent with surrounding land uses. However, Lot E was platted with the intention of it providing open space for development. I don't think that's
Okay.
I don't think that's right, and I'm using his testimony to show
I just
that.
wanted to make sure we weren't getting back in the,
I'm not trying to waste anybody's time.
you're fine. I wasn't saying that. I just didn't want to get lost in the weeds.
But there's nothing on the face of this plat that shows that it was a preliminary plat that went through the preliminary plat process and was approved by some body.
There's no certification on this plat.
Okay. And you pointed out over here on the bottom right hand, just above the word preliminary, there's a little notation about total acreage, total lots, acreage in parks and other land uses. Is that correct?
Yes, sir.
Okay, so by the own words there, other land uses, there are a lot of potential land uses, aren't there?
Yes, sir, it does not specify.
And it doesn't specify that anything's parks.
No, there's no land, no use specified on the plat.
And even on this preliminary plat, it doesn't have lot labels for lots A, B, C, D, and E, and F, does it?
It does not.
Okay, so somewhere between this plat that was, doesn't it say at the bottom that it was drawn 6/6/74? Is that correct?
That's correct.
And somewhere between this plat and 6/6/74, two things changed about it that relate to your prior testimony, right? One, lot letters were added, and two, this provision about total acreage, total lots, and other acreage in parks and land uses was taken off.
Correct. That is not on the final plat.
And on the final plat, it does have, we've already talked about it, but it does have lots designated as A through F.
Correct.
And F is this oceanfront beach area.
Correct.
And are you familiar enough with this area to know whether the oceanfront beach area and these lots like 1 through 11, do they even still exist, or are they seaward of the dune line at this point?
I'm not sure without, that in front of me and aerial photography and such.
And we can get to the I mean, would it help to bring up the GIS and look? You've got the GIS on the computer where you could look, right?
I do on the computer, yes.
Okay, can you bring that up and let's just, everybody look?
Unfortunately, we can't bring it up on the TV, no.
Well, the record note, I tried. I guess if you look in the application, let me show you part of the staff report. Everybody's got this already. It's page 5 of 13, page 15 of 42 of the whole staff report. You already got that?
Yep, yes, sir.
Does it look like there's a row of houses other than the 2 rows that are just east of Lot E?
It does not.
So, and does it looks like there's a lot of water right where Lot F would be, right?
Yes, that's correct.
And just bear with me for a second just to make sure that I cover this, but you weren't the developer of this property, right? You weren't involved in the platting process,
No, sir.
and you probably, were you alive at the time of the plat?
No, sir.
And so clearly you don't have any knowledge of the actual intent of the developer.
No, I'm only basing it on what is in the file and what we can deduce from the file in our professional opinion.
Okay. Let's say this plat, hypothetically, had been a little bit different, and there had been, somebody owned 800 acres of land. They wanted to put it all on a plat, and they were going to say, these lots are on the front side, and on the back side is Lot A. Would that make that have to be open space?
No, sir.
That could be whatever the owner wanted it to be later on. They could do whatever they needed to do with it, right?
Correct.
And on the final plat, and even on the preliminary plat, there is no designation on any of these lettered lots or any other lot or any other part of the survey itself of open space or park or any other reason why they're how they are.
There is no specific use listed on those, on the plat.
And when we came to the Board of Adjustment and did the appeal, and of course I wasn't here, but I have watched the video. All of you look wonderful on camera. But wasn't the perspective that the lot width had to be 110 feet, is that correct?
Correct.
Okay. And it had to be and what the board's ultimate decision was under the 1971 ordinance was that it had to be measured at a line 20 feet from the front of the property, is that correct?
It was measured at the building setback line.
Where would that be?
The building setback line would be what the front yard setback is, which is 20 feet.
Okay. And the front yard was determined by the board under the order to be, and at the time, to be coming from Seagull Lane, basically the tip of the triangular part of the lot, is that correct?
Correct.
And so, not only is it triangular, but it kind of looks like a foot or a golf club or something down there at the end, doesn't it?
Yes, sir.
And that's pretty unique, isn't it? I mean, you don't see many lots that have that sort of shape at the end, do you?
No, I mentioned in my testimony that the shape is unique.
Okay. And if that lot, if you looked at the northwest corner of the lot and ran a line parallel or semi-parallel to the eastern property line of the lot, instead of having the triangle, if it was a rectangle like most lots are, then wouldn't it be more likely that that lot width would have been able to be met?
Well, yes, if you're asking that it would be easier to meet those dimensional requirements if it were rectangular in shape. We don't know what that rectangular in shape looks like, but that is more typical of a lot configuration.
And I don't see how this line of questioning is relevant to the variance application.
They've asked what we want to vary, so I need to talk about what we're
Well, I
talking
think you
about.
can talk about what you want to vary without getting into going back over what the board has already gone over in the prior hearing. The board already determined it did not meet the requirements of the 1971 subdivision regulations and those measurements, so.
And one of the standards here is uniqueness. And I'm just making sure we've got plenty of evidence on uniqueness. It's a unique lot. I mean, he said it's unique, I say it's unique. We're probably
said
gonna
the
have other
shape is
testimony.
unique. He said the shape is unique.
Yeah,
so-
and I want to also show that that uniqueness is what drives the fact that it can't be built. That fact that the front yard is measured from the point of the triangle is what drives the fact that it doesn't have sufficient width, when up farther north on the property, it does have sufficient width. Is that correct? Are you?
Yes, the width increases the further north on the property
And
you go.
are you familiar with the plat that we filed along with the application?
The drawing that was submitted?
Yeah.
Yes.
Got big copies of that for everybody. We got enough of these because Sheree had 12, and we have only 8.
Thank you.
All right, so, Mr. Kemp, when I talk about a building envelope, are we on the same page as to what that would be, kind of the area of a lot that's between all the setbacks, and that you could put whatever use is allowed in that property?
Yes, sir.
The plat that we provided, is there what I just talked about, is there a building envelope shown on that plat?
There is an area on the plat that is noted where the building would be, what the developable area would be.
And it shows a request, it's stated on there, requested NBL. Do you see that down at the southern part of that building envelope?
Yes,
And does it say that at that point it meets 110 feet?
yes,
So there is some point on this property, if you moved the measurement point of the building line to the north, that it will be 110 feet in width. Is that correct?
there are points on this property, yes, where the width would be 110 feet.
Okay.
And what do these setbacks, distance represent on here?
And which ordinance standards are these setbacks and measurements reflecting? The current or the 1974?
I think the setbacks are all the same. Is that correct, Mr. Kemp?
I would have to check. I have my ordinance over there. I would have to check.
But my recollection is that they're all the same setbacks was.
I don't-
Same as what?
I don't know. That's what I'm asking
71
is,
ordinance and the current day ordinance are the same.
I don't have an opinion. I just don't know. That's just a question, which is, are these the reflected measurements, those of 1974 current?
Those are the reflected measurements that we're asking for a variance to grant. And
Is that in the application?
the plat's part of the application, and that's what we asked for, was that we granted a variance consistent with the plat. And if you go through the application, it tells you multiple places that you can do that.
Well, let's stick with Mr. Kemp for now, and then we'll, let's see if we can wrap up with him.
The housekeeping question before we go forward. Is this submitted as evidence?
Right now, it's, I guess technically, I've marked it as applicant one for tracking. I'm certain he's going to introduce it through his expert, Mr. or I don't know if his last name's Bissell, but
Mr. Barr.
Mr. Barnes, I'm sorry.
Mr.
Barr.
Bissell is the engineer for Bissell Engineer.
Barr.
Barr. I apologize. So I assume he's going to, so I think he's using it for illustrative purposes, and he's certainly permitted to do that with, and show that to the, to staff to get his opinion on these and set forth what he's asking for on this. But in terms of I'm sure he's gonna do it in a little bit.
I just was
And give the
making sure
basis
we-
for how we got there and everything.
Make sure we kept our paperwork straight.
Yes, but I've marked it as applicant one, just
Thank
for
you.
tracking purposes.
I take it this property will need septic too, correct?
They have health department approval. But to do anything on the property, each step would have to be done. It's just like any other property. A variance of the zoning that we're requesting would have nothing to do with whether or not they'd still have to meet the building code if they built something. They'd have to meet health department. If there was a stormwater thing, they'd have to do all that. All this is asking to vary is the location, essentially the location of where you measure the building setback line so that there's a sufficient width so that there can be a building envelope that a residence could be built upon.
Right, but keep in mind, as part of this board, we can apply conditions to the approval of the variance. So just trying to understand what those dimensions might look like as we're thinking about that.
And my client, Mr. Delaney is my client, he's here. He's going to testify, and there are some conditions that they're willing to accept that may be useful to the board.
Does that
Do we have
complete
anything
all
else
of
for
your
Mr. Kemp?
questions?
I don't, if I could have just a second, I don't think I have anything else,
Okay.
Mr. Kemp.
There's that space here. Slow.
I don't have any further questions. for
Does the
Mr.
board
Kemp.
have any
All right.
follow-up?
Thank you.
Could we
I
have
have a few
brief
redirect.
recess? I'm
Yeah.
getting ready to lose my voice.
Do
for
the
some-
board have any other questions for him?
I have
Mr. Kemp?
a couple of redirect questions.
Just a couple of redirects, but I
Sure.
think he's asking for a brief recess.
Sure.
I
Would you
believe she
pref-
has some water. I
Would
can
you
have some.
prefer have the recess now, or no?
Go ahead, if she's got some water, I will just grab a water.
Do you want to take a minute, Ben?
No, I'm fine, thank you.
Okay.
Okay, and county attorney, did you want have
Just a
some rebuttal?
couple, yes, sir. Thank you, Mr. Chairman. Just a couple brief questions. Mr. Kemp, you mentioned open space, and whether, I think there was a question whether that was required at the time that this was platted. Is that one of the purposes and intent of the ordinance listed out in that section 1.3 that you were testifying about earlier?
It is one of those to provide adequate open space between uses, is one of those.
Okay, thank you. And does that go directly to one of the variance review standards? The purpose and intent section?
Yes, it goes to the 6th standard.
Okay. And in regard to public safety, would developing this property, do you think that it would increase traffic?
Objection.
Overruled.
There, man,
You asked all those questions about whether fire trucks can
Right.
get through. I mean, you opened the door on that.
I've already
there's a
ruled.
specific statutory provision that requires an expert.
I apologize, but I've already ruled.
Thank you, sir.
Go ahead.
Yes, the addition of a single-family home on the lot versus an undeveloped lot would add daily trips.
And I just will note for the record, there is a specific statute that says that that only an expert can give an opinion about a traffic study, but there can be, I think that he can give his opinion as a planner, but it is not expert opinion, and that the only competent evidence regarding specific traffic impacts by statute can be rendered by an expert, but he can
Yeah.
testify
And the
about it.
same expectation goes for the opposing counsel, being that they had questions about.
That is a statutory
If it's
application
good for
about
one, it's good for the
traffic,
other.
traffic impact, so.
So then I can,
And
I
for the
can
record-
rephrase, as my opinion is that it would increase trips.
For the record, we don't disagree that it'll increase. It's going to have to increase because people use the property. The objection is to testimony of how that relates to public safety. I think you have to be a traffic engineer to connect the two.
Thank you. Any other rebuttal?
A couple more questions. So Mr. Gallup was asking questions about the differences between the preliminary plat and the final plat, and how the acreage and parks portion was taken off. But do both plats indicate lots and numbered lots at the bottom of each plat?
Yes, both plats indicate that it is for lots 1 through 33.
And on anywhere on either the preliminary or the final, does it say lots A through F?
It does not.
Okay. Okay, and then in looking at this plat that was provided by the applicant that was being used for illustrative purposes, do you typically, how many years of experience do you have in the field of land use overall?
12 years.
In your 12 years of experience, have you ever seen a building setback line move like this in this plat?
Objection, relevance.
Well, you're asking to vary from the building setback line. How is that question not relevant?
That's completely relevant.
Doesn't matter about what
Overruled.
other things have been done.
Go ahead.
In my experience, the building setback line has always been at the setbacks identified in the ordinance. It's never been at an arbitrary point of the lot.
Okay. No further questions.
All right. You go ahead and present your case. Are you done with the witness?
One more quick question. Mr. Kemp, I think we kind of glanced over it a minute ago, but we didn't go through it. The preliminary plat is not recorded in the Register of Deeds office, is that correct? The one that says preliminary on it that we were calling preliminary is not recorded in the Register of Deeds, right?
That is correct. The final plats are recorded.
And there are two final plats, but we're looking at the more final of the
Right.
two?
There were two. There was one plat recorded, and then there were slight changes made to a right-of-way and easements in there. So the second one was the last one recorded, and that's the one we have in front of us.
And there weren't any significant differences between the two that are recorded with regard to Lot E?
No, sir, there were no differences in Lot E.
All
I
right.
don't have any more questions.
Thank you, Mr. Kemp.
One last question, Mr. Kemp. So just for the record, for the 6 criteria, the county is alleging that 2 of the criteria are not met. The hardship is a result of the applicant's own actions, and the requested variance is not consistent with the spirit, purpose, and intent of the ordinance.
Yes, and then there was a portion, we did mention that the uniqueness, yes, we recognize it is a unique shape and configuration. However, we did note that there were 7 A through F such lots on the plat.
Right, but those lots had other circumstances that allowed
Correct.
them to be.
Correct. Each lot has its own individual layout dimensions. So we are recognizing that there is a unique shape to the lot.
And evidently, they met dimensional standards at the time that a lot was created.
Which lots are you referring
You
Those-
determined
of
that
those two,
already.
right, of those two.
Yes.
The other lots.
Oh, the ones that were.
The ones that were
combined.
developed.
You can make a lot any way you want. It doesn't, it just may not be
I thought you were talking about the lettered lots. So I misheard.
Thank you.
Thank you.
I think you're done, Mr. Kemp.
And do we want to mark the staff report and attachments as County 4?
Yes, thank you. I would like to move to introduce the county staff report as County Exhibit 4.
Okay, so enter.
Thank you.
Did you all require a break for a minute?
I'm sorry.
Oh, what?
That'd be County 5, I believe.
Okay, so.
We have.
The order is 1.
The order was 1. This was 2. Preliminary was 3.
You're right, it's 5.
It's 5,
So
yep.
Yep, it is 5.
All right.
I apologize. I wrote 4 before 4 came, I guess.
And that would be the county showing.
All right. Do you all require a break?
That'd be great.
Okay, let's take a 5-minute break. All right,
Chair, would you prefer he go up here to testify or stay here?
yeah, he can be right here, it's fine, if he can come right on up.
Sure. I'm gonna call.
And I would like to remind you, Attorney Gallup, if we can keep on the gist of what we're here for today and not rehash everything that happened at the last hearing, if we can stick to those things, it would be great.
I don't have any interest in, the whole point was that we're stuck with whatever the last hearing was, and that's part of why we have to have a variance. Mr. Delaney, can you state your name?
Yeah,
For the
Edward
record.
Delaney.
Do you own the property that we've been talking about tonight, Lot E of the Seagull subdivision in Corova?
I do with my wife Tara.
Okay. What's your history with the Outer Banks?
My family from New Jersey and my wife's family from New Jersey would summer on the Outer Banks, specifically in Corolla, probably now for the past 25 plus years. And it became a annual ritual to be down here with the family for 2 to 3 weeks. And that's what kept drawing us back to visit and stay. And then an opportunity presented itself where we thought, my wife and I thought that it might be a good idea to entertain, hey, maybe we can buy a lot and maybe we could build on it and maybe this could be a home for us. And in doing so, we engaged a realtor and we purchased the property in '03 with that idea. The idea was this is going to be our dream place. Now, keep in mind, my wife and I are both in our mid-60s, and this was 25 years ago, 20 years ago. So our mindsets were a little bit different then. But that was the intent. The idea was that this could be a place that we love. Love the ocean, love the area, family loves it. So that's our background of how we got here.
After you bought the property, did you actually consult with anyone about building?
Yeah. After the property closed, we had several meetings with several builders, although it's 20 years back, I don't recall, just to get an idea of what can we put here. We don't want a McMansion, a simple 3-bedroom, 4-bedroom home. And we actually had involved discussions with at least one builder. Again, I don't recall who it was, where they were putting together the figures and that kind of thing. But then life kind of went on, and 20 years later, we thought, well, maybe our son. We have one son. He's 30 years old. We thought, well, maybe he would like to have the property. And this is going back maybe 3 or 4 years ago. He says, I don't have any interest in it either. And our perspective and our goals and things in life had changed. So we contacted a realtor, and the realtor said, I had no clue what the property could be worth. I couldn't tell you if it were here or here on a scale. So the realtor came up with a number, again, going back about 2 years. We had an offer on the property, and the prospective purchaser, we were then notified by council that they had done some investigation, what can we put here, blah, 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 and it was determined not to be buildable, and that just shut everything down. But the whole idea was, this was, a part of what we envisioned ourselves with the dogs and the four-wheel drive and the fishing lines and, what you see.
What do you do for a living?
I'm an attorney.
What is your wife, did you already say what her name was?
Tara Murphy.
Okay. What does she do?
She's an attorney.
What kind of law do y'all practice?
We have, the firm is Delaney and Murphy. It's I would call it a mom and pop small firm. We've been in practice I've been in practice 36 years. My wife has been in practice probably 33. She went into the corporate law thing, and I struck out on my own. We had our son, and she got out of corporate, and we joined up. So it's been a very small, family-oriented, repeat clients. We have clients who are now, the grandchildren of clients that we started with, 35 years ago, and that's the pleasure of what I get out of the practice today. But we're well into the initial stages of thinking about retiring and working less, and we do work a lot less now. COVID hit, it had a huge impact on the practice, so the work itself is whittling down as primarily part-time now.
And have you ever done any land use law related to permitting and stuff like
Never.
that?
35 years, I've never touched a land use case. My practice was primarily, well, back then it was bankruptcy. We also currently do a lot of matrimonial law. We do trusts and estates, and we also do what I call traffic court, municipal court, speeding violations and, that kind of thing.
But as a lawyer, did you read orders from courts and things like that?
Sure.
So are you familiar with the Board of Adjustment order from last year?
Yeah. Mm-hmm.
You've read it?
Yeah.
And what's your understanding of what it allows you to do with your property?
Nothing. My understanding is that it's not buildable. It's got no reasonable value whatsoever.
So does it have any reasonable use?
No, not according to the way it sits today.
Okay. When you bought it in 2003, did you know that it wasn't buildable?
No.
Would you have bought it if it wasn't buildable?
No. No, I didn't. No.
And you've already talked about that the first time you ever heard anything about that was after the contract period with the...
Yeah, and that was a huge shock.
I don't have any more questions for Mr. Delaney.
County, have any questions?
Just a couple. Excuse me, keep coughing. Mr. Delaney, if you were to receive this variance, what is your plan regarding this property?
Objection. It's not relevant to whether or not the variance should be granted. The only thing that's relevant is whether or not they meet the standards of the ordinance.
I think it is relevant because it goes to the hardship that I'm laying the foundation for the hardship that he is suffering.
I'm not sure what you mean by hardship.
Yes,
Okay,
I will.
I'll move on. So prior to finding out the lot was not buildable,
Yeah.
you had this lot up for sale.
No. Well, Yeah, yeah.
So your plan was to sell this lot to someone else?
Relevant.
Well, no, as I
You
said
asked the
before,
question, what he was doing and what led him to be here.
as
And
I
he
said,
told you
as I
when he
said
found
before,
out.
we were holding on to it. We had held on to it for 20-plus years. Our dreams, our hopes, what I said about the dogs on the beaches, and our son didn't want the property. So for us, it just became an issue of, well, why hold on to it anymore? God forbid, I could be dead next month, my wife could be dead next month. That just creates additional problems in the world. Let's just get on with it. Aside from the fact that we have a pie in the sky idea that we may be moving again, and we won't be anywhere near the Outer Banks anymore. We currently live in Florida because my son went to school there, and my wife doesn't want to be away from baby boy.
No further questions.
Does the board have any questions for him? I want to clarify with you, if you don't mind. Thank you for coming tonight. We appreciate it. At what point did you find out that it was not able to be built upon? Was it prior to listing it for sale?
No.
Or was it at the time?
Yeah,
When a
at the
potential
time.
buyer
We had
found out?
no clue, and it just hits you on the back of the head.
So when you purchased the lot in 2003,
Yes, sir.
no, that's when you attempted to sell it, is that correct?
No, '03 is when we purchased it,
Is when
20
you-
years
is
ago.
When you purchased it, you did not ask the question or do the research to find out whether it was buildable.
Well, we had a title company, we had an attorney. I just assumed that at the very least in the binder of the title report, that it would have some type of flag, and the title company would have called it to my attention, or the attorney would have called it to my attention. I would have, it was, the contract probably says purchase a lot for buildable use. I don't recall, but that was the intent, would then be to purchase it, meet with the builders, as I said, and then life kind of took us in different directions.
You didn't ask the question, or
No, we didn't ask the question as to whether or not it was buildable, because it just seemed we had a reputable realtor, Riggs Realty, who's maybe reputable, maybe not, I don't know, but from the look on your face, I'm not sure.
I have no reference on that.
But, yeah,
And I guess my question is, when you guys purchased the lot, you saw what it looked like in terms of, its layout, the dimensions of it and everything. Didn't that ring a bell? Said, it doesn't look like the rest of these Seagull lots.
no, because the conversations that we had post-closing were with a builder, and we had a survey done before we closed on the property as part of the title, blah, blah, blah. We had a survey done. And you could see from the survey that there was the ability to, and the builder would say, the house goes right here, and here's the septic, and here's this, and here's that. We had the soil tested, all that. We did all the preliminary things that we wanted to do in the intent of owning the property and having it as ours.
And the surveyor didn't say it wasn't a buildable lot?
No. I don't know that, again, I don't know what the parameters are for them to go and check, oh, is it buildable or not? It's, looking at it, the idea was, or the builder, that is, said, marked it on the plat over toward the far right side. That's where your home could be.
Right.
And I think you said earlier in your testimony that had you known you couldn't build anything on that lot, you would not have purchased it, correct?
No. The fancy answer is no, because I wouldn't say, well, you know what, I'm going to deduct 99% of what you're asking for, and I'll give you $1 for the lot, that kind of thing. It just never, ever even dawned on us. We had No clue.
Any other questions from the board? Any rebuttal? All right, you can go ahead and call your next witness.
Thank you, Mr. Chairman. I'll call Michael Barr. Good evening, Mr. Barr. Could you state your full name and occupation for the record?
Michael Douglas Barr. I'm a professional land surveyor and have been since 1976.
Where have you performed surveys in your career?
My career has been split between the Triangle area and the Outer Banks, about 50-50.
When did you start performing surveys on the Outer Banks?
1976.
I won't ask you what month, since that was the year I was born. Have you performed surveys in Currituck County?
Yes, I have.
Have you prepared subdivision plats?
Yes, I have.
For submission in Currituck County? Have you prepared subdivision plats for submission that have been accepted in
Yes,
Currituck
I have.
County? I'd tender Mr. Barr as an expert in surveying and subdivision design.
We accept that. Thank you.
I don't know if Mr. Kemp kept his copy or left it up there, but there's the survey that is applicant number 1. Do you recognize that survey?
Yes, sir.
Is it a plat that you prepared?
It is.
What is it a plat of?
It's a plat of Lot E, Big Gulf subdivision, as it was recorded in the recorded plat that was brought in the record earlier.
I'd move for admission of applicant Exhibit 1.
Accepted.
Mr. Barr, I just want to kind of go through the plat with you and look at some measurements. So let's start up at the northern part of the plat. I talked with Mr. Kemp about a building envelope. Can you describe what the building envelope is on this plat?
The building envelope is made up of requested setbacks as well as county setbacks that are required.
Okay. And what is the setback from what's shown as Sandpiper Road?
The front setback is, or from what we were calling the front setback on Sandpiper Road, was 20 feet.
Okay. And then, I recall, I believe the Board of Adjustment last year said that the front was from Seagull. Is that correct?
They did.
Yeah. So the front setback would be the one on the southern portion of the envelope? The front requested setback would be the one on the southern
Yeah,
portion of the envelope?
down in the very front, we drew in a red line that shows what the county has stated that the setback was.
So I just want to clarify, just as a reminder, because it's been a minute for the board, is that the front setback is established by the ordinance because it's a corner lot by definition. And Mr. Delaney's attorney last time established that it was a corner lot, which actually set that setback line as the UDO sets it, not, the board didn't interpret.
But that's what the board's order.
That's fine. I just
determines
want
as
to
the
make sure that
setback
the
line.
board that everyone remembers that was based on the ordinance. They didn't actually determine that from something.
And again, we're not rehashing that as much as to show that's where it is. That red at the bottom is where it is. And what we're asking is to move it up to where it's shown on the building envelope. So going back up to the building envelope, Mr. Barr, you were just talking about the setbacks related to the county's position, but at the bottom, the southern portion of the building envelope, there's a requested minimum building line, is that correct?
That's correct.
And what would be the lot width at that point?
At the minimum building line? We're down to the southern portion or
Yep.
down, probably about 60 feet. at
I'm
the
talking
most.
about the minimum building line on the envelope that
Oh,
you've
it would be
shown.
20 feet from the road.
The one that goes across from east to west.
Well, actually, it's a corner lot, so I think there's typically, you have a 20-foot setback on both sides.
Yeah. I guess I'm not asking the question very clearly. The line that goes east to west, how long is that one?
I don't have that information on here.
I mean, we're not looking at the same place. May I approach, Mr. Chair?
Yes, you may.
He's looking at
This
What are you
line is
talking
at the
about?
southern portion of the building envelope.
It's 110 feet wide.
I apologize for my fault not being able to get him into the right place. And so you've got 20-foot setbacks along the eastern and western boundaries and a 25-foot setback along the northern boundary of that?
Yes, sir.
And then, can you tell the distance that 110-foot line is from Seagull Lane to the south?
I don't think we have that on here. My best guess is somewhere around 400 feet.
All right. And so the building envelope's got some other information in it. Or what's the square footage of Lot E? The whole lot?
The whole lot is 41,876 square feet.
Okay. And what's the square footage of the building envelope north of the requested MBL of 110 feet?
The entire area above that 110-foot line is 18,641 square feet.
Okay. And then the area within the minimum building line shown on that envelope, how big is that?
9,697 square feet.
Okay. Is that sufficient area to build a single-family residence?
Yes, sir.
All right, and we were looking earlier at County Exhibit 4, so it might be a full-size version of that up there to you. It's the recorded final plat that's, I think it's Plat Book 5, page 50, what it seems to be showing.
Yes, sir.
Do you have a copy of that you can read the numbers on the subdivision lines?
Yes, sir.
Okay. So, have you looked at Lot E in comparison to the other lots in the subdivision?
I looked at Lot E when we were requested to survey it. I really didn't ever compare it to the other lots other than a pure request comparing the types of development that are around this lot.
And looking at this plat, would you say that Lot E is unique in its shape and location and topography compared to the other lots?
Yes, very, very unique.
Okay. If the variance were granted and the board provided for a single-family residence to be allowed to be built within the building envelope that's shown on the plat you prepared, how does that compare to the building envelopes of the other lots in the subdivision?
Very similar.
So when you say very similar, I mean, I'm looking at Lot 21, it's about 20,000.
About 20,000 square feet, yes.
And we're talking, 18.5 to 19,000 square feet for the same sort of area on what we're asking for. Is that correct?
Correct.
And the setbacks are all very similar. In fact, I guess there's no setback shown between lots, like 21 and 22 and 20 and 19, that there are no setbacks even shown on those lots, is that correct?
They're only, I think they showed the front building line, and that was it.
Okay, so we would have, you know, a larger, more setbacks than those would have.
Objection, he continues to lead the witness.
Yeah, sustain.
Is there a road right-of-way just to the east of Lot E?
Yes,
And how wide is that road right-of-way?
60 feet.
Is 60 feet sufficient for fire, EMS, and law enforcement access typically?
Yes, I believe it is.
Would there be any difference in the ability for law enforcement, EMS, and fire to be able to?
Objection. I think Mr. Gallup tendered Mr. Barr as an expert in subdivision design and surveying, not in public safety, fire.
Yep,
that sort
sustain.
of thing.
Mr. Barr, when you design a subdivision, do you take into account whether or not EMS, fire, and law enforcement will be able to access properties?
Yes, we do.
And is one of the ways you take that into account by making the road sufficient width to do that?
Yes, sometimes it's because of that particular section, or it may be because the ordinance requires a right-of-way to be of minimum size.
But that's a common part of your professional practice?
Yes.
And that's a common part of subdivision design, is that correct?
Leading the witness.
Let's not lead so much, and just to be clear, are you asking him only about the road width, not the relation of access in regards to public safety? I mean, are you tendering him as a traffic impact witness?
It's anything about traffic. It's about whether or not public safety vehicles can access the property.
And you're talking about just the width of the road? That's what
Yeah.
I'm asking you. Because you're saying, is there any difference to this area than other areas? I mean, so that
Well, you don't even have to be an expert to look at it and say, there's no difference in.
objected like 30 minutes ago to a question about tying traffic impact to safety. And so I'm just trying to streamline this and say, if you're just asking him about the width of the road and can emergency vehicles travel on a 60-foot wide right-of-way, I think we're good.
That's all I'm asking.
Okay.
Well, I'm asking something else, but it's not related to traffic. What I'm asking is, can EMS, fire, and police that can travel along that road access Lot E just as easily as they can access Lot 21, 22?
Yes.
Your objection was sustained, by the way.
Would you have any public safety concerns using this lot as as proposed in the variance application for a single-family residence?
No more so than any other lot in Port
Ms. Morgan asked Mr. Kemp earlier, in his career, had he ever seen minimum building lines moved? You recall him answering that question?
I do, yes.
Have you ever seen it in your career?
Yes, sir, we often, because there are multiple subdivisions in Currituck County and other places where there are irregular shaped lots. It might be at the end of a cul-de-sac, it might be a flag lot, where the minimum the county requires might be 20 feet, but it also requires a minimum width. So in order to get the minimum width, the setbacks are often moved to meet that requirement. So you might have a setback that's 50 or 60 feet on a lot, or in this case, 400 or 500 feet, to get to that point where you can meet the minimum width for the lot. And that's where you put the building setback.
And would that be essentially what you've done with your plat?
Yes.
Was that all your questions for the witness?
I hope so. I'm running through a couple things just to make sure I didn't miss anything. I've unfortunately got a lot of paper on my desk. That's all I have for Mr. Barr.
County?
Yes, just a moment. I need to look at something.
Attorney Sankinet, do you have any questions thus far for Mr. Barr? Anyone on the board have any questions for Mr. Barr right now?
Yeah, I do. When you said that the area within the building setback 9,697 square feet, and the question was asked, is that enough room, enough area to
Well-
build a single-family residence?
Single-family residence probably normally has a square foot of about maybe 2,000 square feet. So it would be unusual, since he said he didn't want to build a McMansion. There are some houses up in Corova and Corolla that are over 10,000 square feet, but you could build a 9,000, potentially a 9,000 square foot house inside that building envelope.
And you also said that the numbered lots, 21, 20, the ones adjacent, had similar areas for building?
Well, yes, they do. The lots are, I think in the case of those lots, they may actually have less width than the area that we're talking about, that we show on the proposed building setback lines, because I think most of those lots are maybe 150 feet, and we're probably somewhere around 130 feet of frontage.
Those areas on those other lots, it looked like as you said, they're all kind of hovering right around 20,000
Yes.
feet. And this area minus the setbacks, or actually including the setbacks, is 19,000?
Yeah, 18,641 square feet. Of course, that's not the entire lot. The entire lot is the 41,000 square feet.
But we're talking about kind of the
Similar, to make it kind of eggs to eggs.
parallelogram. Yeah.
So everything would sit in there, the house, the septic, all that kind of stuff, no problem.
Say again?
Everything could fit in there, a house, the septic system,
Yes,
everything. Adequate parking, et cetera.
I think so, yes, sir.
And I guess I think that he would be I'll wait until the county asks their questions, but in terms of what specific things you're asking to vary, I think the board needs to understand what you are asking and how, you're asking that this plat that whatever variances have to be granted to give us this plat, and I think he'd be the one to be able to answer what areas of the ordinance that this plat would impact.
You can ask him. I don't think he'll be able to answer. I think that's my purview in argument to talk about that. I don't know that he knows the provisions of the ordinance, other than to move you can ask him.
The only thing I would say to that is that what we're showing as a buildable area is similar to the adjoining lots around it.
Sure. And I guess my question, because the variance is, the board needs to know what they're varying. And so are these measurements based on current UDO standards, the setbacks? Or are these just the setbacks that were requested by the applicant for you? Like, can you plat this out on our parcel, or did they provide you? I guess I still don't know what you're asking the board to vary from. Is it 1974? Is it 2023? So I'm asking, are these standards just the standards they gave you, or are they related to the UDO? Maybe that's the better question.
We attempted to show the setbacks other than that setback along the 110-foot line to be in line with the present-day setback requirements. And what the setback requirements were in 1974 one, I'm not sure,
Okay.
but I'm guessing they're probably pretty similar.
Okay, so these measurements here are the current setback requirements for.
We actually,
Currituck, sorry.
it kind of depends on which way you look at the lot.
Okay.
We added some on the east side on Sandpiper Road. If that were a side property line, it could be 10 feet, but since it's a corner lot,
Right.
we made it 20 feet. The property line on the rear, we made 20 feet, and I don't have an answer to why that was 20 feet as opposed to being 10 feet. It's just a matter of how you look at the lot and how you would design those setbacks. But the setbacks shown are at least, or more, or at least the minimum, and in some cases, more than the minimum
Of the current,
of the current.
of the current standards.
Yes.
Okay.
I got one other question. So, in terms of assessing this as a buildable lot, we're working with the area north of the 110 line?
That would be the buildable area, yes, sir. You couldn't build a house below that 110-foot line. South of that 110. You'd have to be up, but because we've said that, the lot has to be 110 feet wide at the building line. So that makes the minimum building line be where it's located on the survey.
I got you. So, what you're saying is you could build a house on where that line shows on the map?
Right.
Plat. Okay. Thank you.
And the whole structure, including, and I think Sam asked, septic, well, whatever would need, it would have to be within that? Or could the septic be put down here?
Septic could be
or-
wherever the health department approves it. So it could be anywhere on the lot. It doesn't have to meet building setback lines. It has to meet the setbacks that the health department require.
Okay. So then they would determine where that would go. Okay.
It is possible there's enough area there that it could all be in that area, but that doesn't prevent him from putting the septic down here somewhere if it works better.
Okay.
Any other questions?
Just one
County, go
question
ahead.
from the county, just one question. So in order to achieve this plat that you've done, what specific provisions of the Unified Development Ordinance need to be varied in order to achieve this?
I'm not an expert on the ordinance, so all I would say is that opposed to the 20-foot front setback that is shown in the UDO, we are proposing a setback that's much greater than 20 feet to make it be the proper width that was required in 1971.
Thank you.
No other questions
I
from the
do,
county?
that leads me back to my question of, are we talking about 1971 or are we talking about 2023? Is the lot width the same now as it was in 1971?
Is the legal lot width requirement?
Right, I asked, the
I
question
think-
is, what are you asking to vary? And are you asking to vary based on the 1971 standards or the 2023 standards? What are you asking this board to do? And he just said the 110 is the 1970 measurement, so is that the current standard?
Which,
Lot width?
No, it's 125 is the current standard.
I'm sorry, what was that?
125.
I want to understand, the board needs to understand what variance what they're being asked to vary.
they're asking to set the width at 110. Whether that's a
Move the
variance
building
of the
setback
one-
line and move it to 100, to a width, to have the 1971 lot width.
just like the lots across the street.
That was my only, I just wanted to make sure we understood what standards you were asking to vary.
Do you have any rebuttal for your witness?
Nope.
Are there any other questions from the board for Mr. Barr?
Excuse me, Mr. Barr, just briefly, I don't see where the access would be defined. Typically, if you do a plat or something like this, you might indicate where the access would be. If you're calling the 110-foot width the front of the lot, is the access from Seagull?
I think the access would logically be from, sure I get my rate, from Sandpiper. There's not enough room to put an access, nor would you want to put an access down on Seagull and have to run a driveway up 700 feet when you've got a road right there at your front door.
Thank you.
Okay, I got one more question. We've established that this, and Ms. Morgan said that the current width is 125, is that right? What was established of this 110 width line? Where did that come from?
Are you asking Mr. Barr?
I guess I am.
Yeah, it came from the 1971 requirement.
Okay,
It's right there.
thank you.
So if it came from the 1971 requirement, are we asking for a variance from the current UDO width requirement, 125?
I tried to, I'm not very good at explaining it because I'm not very good at understanding it. You could do it that way, or you could do it because the 1971 ordinance is incorporated by reference to a degree in the lot of record definition because it went back to that. But ultimately, you can say you're varying it from the current day to be consistent with the building envelope of the neighboring lots as they were developed in 1971. Even if this was a bigger lot or a more conventional lot, it wouldn't be consistent with them under the current day. But what we're asking for is to be consistent with them and have that building envelope there, which would result in a lot width of 110 feet with the setbacks that are shown. So if you want to consider that as a change from the current today's setbacks, I think you can do it that way, and that's fine with us. Or if you want to consider it from the 1971 setbacks to make it meet the existing lot of record language, then that's fine with us. I think either one of them is a possible way to do it, and I think the key is that
determined that it
I've
didn't meet that
asked.
definition.
That's the whole point of a variance, is that it
So you're
doesn't
asking
meet
them
the
to
definition.
go back and change their mind about what they already decided?
No, that's the whole point of a variance, is that we only come here when the definition and the measurements make it so we can't do what we want to do. What we're asking to do is change those so that we have a different measurement so that we can do what we want to do. I'm getting a little bit more into argument than I want to, so please cut me off if you want me to stop. But
Well, I guess let's see, it sounds like we might be at argument and nobody has anything else for Mr. Barr, and we can probably let him go from sitting up there. Does anybody have anything else for Mr. Barr?
I don't think so. You're
So,
free to step down,
Sounds
Mr.
like,
Barr.
I think we're
Thank you.
there.
And Mr. Gallup, it also appears that from Mr. Barr's testimony, it sounds like you all are wanting to change what direction is the front of the lot. Instead of it being on Seagull, now you're wanting it to be on Sandpiper as far as the front.
No, I think he said that the Sandpiper would be the logical.
Right, for a
entrance.
driveway, but if
But-
it's,
yeah, but
the
that may
driveway
not be
typically is
the-
on the front.
Yeah.
I think the best way to deal with that would be to set a condition as to where the access is, but I don't think access requires a driveway being a certain point. I think the requirement for access means you have to abut and be able to access legally a roadway, whether it's in the front or in the back or wherever it is. I think the access requirement doesn't drive the location of the driveway. What drives the location of the driveway is where the owner wants it and where it fits best on the property. There may be some requirements about not putting that on a corner or something, but usually a requirement for access does not drive the direction of or the placement of the driveway. But either way, I think there's multiple things that our client would be willing to consider on conditions. One would be where to put the driveway, or where to have the driveway access come from. Another would be,
Are we doing closing arguments or what's going on?
Well, I think he's trying to respond to one of their questions, which
Okay.
was about the driveway. So without getting too far into additional conditions, as I'm sure you're gonna tell us what he's willing to do about conditions. Regarding access, are there any limitations to access? I mean, the board's asking this question about access, so if they wanna put a condition, I think they need to know what they can and can't do. Do you know the answer? Or Ben, do you have the statute, the ordinance on that?
I mean, I have the ordinance here, but I'm not aware of anything that says it has to be from a certain street. My only understanding is that there has to be legal access to a roadway, or there might even allow
The
private
reason I
easement.
ask is, again, because if the board is gonna consider a variance, they need to understand all of the impacts that variance they grant is going to have. And so that's why I asked that question, if you know.
I think Mr. Kemp can answer that.
Section 5.67 speaks to driveway and access standards, and on corner lots, it says driveways on corner and double frontage lots shall provide access from the street with less traffic to the maximum extent practicable. So there is flexibility there. It doesn't specifically prescribe
Just
Where
whichever
the
one has less
driveway.
traffic, is that what you said?
to the maximum extent practicable.
Okay.
Mr. Kemp, am I correct in saying that this is actually addressed in GIS as Seagull? Is that correct? Like 0 Seagull? Is that the address that's listed on
I don't.
GIS?
I don't believe this parcel has a physical address. It just has a parcel identification.
But it's listed as being on Seagull or fronting on Sandpiper?
I think that the frontage is the front of the lot by definition, this is what I recall from the last hearing in the order, is
Right.
Seagull because it's a corner lot, and that was the that's how we got to the Seagull Lane, and it's because it's considered, by definition, a corner lot. And so that's why it's on Seagull, but I don't know that there's an address or anything other than the fact that it technically by definition.
A lot of land on GIS will have the indication of 0 Seagull Lane or 0 Sandpiper Road until a dwelling is put there.
Okay, I just wanted to make sure your question about access was answered, so that when you hear the arguments, you have,
Okay.
the information, available. So are there any other witnesses or
Yeah.
evidence to be presented at this time?
Are there any other folks that signed up to speak about it?
What do you mean it says?
Okay. Well, we'll close open the public comment period. There are no public comment people to speak, so we'll close the public comment. And I guess we're ready for closing arguments now.
Are you going to go first, Ben? Or,
Do I get to come back?
well, I guess technically, if we're following the rules, then you presented evidence, the county can waive opening, you can argue, and she could finish, I think, or, I don't know that there's really any particular way, but
I don't care.
I don't know that it matters. I think that there's probably gonna be more questions anyway, so.
Yeah, it's not a big deal. One thing that was important to me in the questioning that y'all had was we talked about the other lettered lots that got developed. And somebody said something was done to let them get done. This is the something that's to be done to get this one to be built. Everything's got a process. And variances are a process that are in the ordinance, that are driven by statute, and then driven by the Board of Commissioners adopting the statute. And I want to get into that a little bit, probably more than you want to know, but I think it's important because Ms. Morgan is going to harp on this issue about economics. So I've got to build for you a little bit of history and understanding about variances. In North Carolina, counties and municipalities are creatures of statute. There's enabling legislation that tells you what you can and can't do. And the current enabling legislation for variances is 160D-705, and if I could approach and provide you this language.
Yes, you may.
Oh, I have one of those, so. I have one. I can pull it up, you can pass it down.
Thank you.
Hey, Ben, and just, we forgot to submit your, your application package as applicant two, and just cleaning up for that purpose. I think we just kind of glossed over that at the end.
We'll accept that as applicant
you're-
too.
Just want to make sure it's included in everything.
So I've highlighted the variance provisions for the statute. And you can see, just like the county's ordinance, there are only 4 provisions, but if you look at the last one, this no change in permitted use may be authorized by variance, that's kind of one of the other provisions that are there. But the statute has 2 things that are important that are not in and not stated in the ordinance. One of them is in number 1, that that it is not necessary to demonstrate in the absence of a variance, no reasonable use can be made of the property. And the other is what I talked about with Mr. Kemp, that the act of purchasing property with knowledge that circumstances exist may justify the granting of a variance is not a self-created hardship. So even if they knew that they couldn't build on this lot, the general statutes tell you that you can't use that as a self-created hardship. And a case I'm going to tell you about in a little while will tell you that even if they knew, if it makes it so you can't do anything on the land, you still have to grant the variance. The important part about the showing of reasonable use comes back to Ms. Morgan's discussion about these provisions that she says can't be part of an ordinance or can't be part of a variance. And they're important because variants have a long history. The Board of Adjustment has a long history. It goes back about 100 years, early 1900s, 19-teens. New York started with the whole concept of zoning and boards of adjustment, and it came down here in variances. And in let me hand you something else. In 2013, there was a session law passed. So session laws are when the General Assembly passes a law. And I gave you my, I'll do that again. I'll do that. But session laws are when the General Assembly passes a law, they pass it via session law, and it tells you what it changes about the general statutes. And at this time, the general statutes, we didn't have 160D, we had 160A. And the correlating provision to the 160D 705 provision that I just showed you is 160A 388. And if you turn to page 3 of what I've provided is NC Session Law 2013-126, you'll see a highlighted portion where it talks about variances. And what's there, if it's got an underscore, it's new. If it's got a strike through, it's old but going away. And if it doesn't have anything, then it's not changing. So prior to this enactment in 2013, what it said was, when unnecessary hardships result from the carrying, or when practical difficulties or unnecessary hardships result from the carrying out of the strict letter of a zoning ordinance, the Board of Adjustment shall have the power to vary or modify any of the regulations, provisions of the ordinance so that the spirit, so the spirit of the ordinance shall be observed, ordinance such that public safety is secured and achieved, or in substantial justice is done. So it had that's all it had. It didn't have these 4 standards prior to 2013. However, most ordinances had adopted similar standards to what got adopted in 2013. And Currituck, I'm going to hand up a couple of things. What I'm going to hand up first is the variance section from sometime around 2010. My file number said August of 2010, and then sometime around 2013. But my file number for that, it was right when the UDO got adopted, and it says January 1st, so it was probably before this provision was changed in the General Assembly.
Is this yours?
No, all
Okay.
of them have highlights.
Okay.
Mine says BMG in the front.
Okay.
I actually did it right this
All
time
right.
and set those on the table.
I just don't want to
before
keep yours
started
if it
walking
was.
around. I really apologize for how long this has taken, but unfortunately, it's important to explain. Those land use lawyers, those are kind of fun.
There are two pieces that you're.
Yeah, I need,
Give you-
yeah, I need one also. That's the one I have.
You got that one.
Okay.
Thank you. So this is Form,
For argument, they're not actually
Okay.
exhibits.
okay.
Yep.
So, if you look at the one that says Chapter 13, Board of Adjustment up there, this is the one that was, my file said it was sometime in 2010. And if you look at the variance standards, one important difference is highlighted compared to what changed in 2008 or 2013, is that it says a variance may be granted rather than shall be granted. So the shall makes it so if you meet the standards, you know, I've heard this before, if the standards are met, you have to give the variance. When it was may, there was some question about whether or not you had to give it, even if the standards were met. But that changed in 2013 from the statute perspective. And the other part that's important to note is that this number 1 says he can make no reasonable use of the property. And I'm going to get to why that's important in a minute. But if you go to 2013 one, which looks like the more modern UDO provision, and I've highlighted variance at the bottom, and then you go to the standards, you can see where it was changed to shall be approved. That was kind of a trend even before the General Assembly made its changes. But you can see D1 where they still said results in no reasonable use of the land. And then you can see where that E was added with the grounds not for a variance, that there are not grounds for a variance. But again, that was added prior to the General Assembly adopting specific language that said what the standards are for granting a variance. So that's really just to provide you with a little bit of history, a little bit of background on the Currituck variance and how we got to where we are today and how we got to the general statutes. I could approach one more time.
Yep.
A moment.
Come on up.
What I'm handing you now is a case from 2016 in the Supreme Court of North Carolina called Quality Built Homes versus the Town of Carthage. And all I'm handing, this case was about what are called adequate public facilities ordinances, and it doesn't relate directly to what's going on here, but what it relates to is, if you turn to page 5 of 7, it relates to how you look at enabling legislation and how it affects what's valid in the ordinance and what's not valid. And what it says is, and one thing that's important here is this is a municipality case, but it applies equally to counties. And the case in here that it cites, the Lamble Homes case v. Cabarrus County, I've got copies of that, but I think it's 28 pages long each. I'm not going to hand it to you. I might just say a couple quotes out of it. This one's a little bit better at putting the language together, but it applies to counties just as it does municipalities. The General Assembly delegates express power to local governments, municipalities is what it says, by adopting an enabling statute which includes implied powers essential to the exercise of those which are expressly conferred. All acts beyond the scope of the powers granted to a municipality are invalid. When determining the extent of legislative power conferred upon a municipality, the plain language of the enabling statute governs. If the language of the enabling statute is clear and unambiguous, there's no room for judicial construction, and the courts must give it its plain and definite meaning. A statute clear on its face must be enforced as written. If the enabling statute is ambiguous, the legislation shall be broadly construed to include any additional and supplementary powers. And then it talks about that are reasonably necessary, expedient to carry them into execution and effect. The broad construction mandate of Section 160A-4, there's a corresponding 153A-4 that has the same language applicable to counties, is a rule of statutory construction rather than a general directive. And as such, it is inoperative when the enabling statute is clear and unambiguous on its face. All right, so what's the point? The point is that 160D 705 is the enabling legislation. And unlike prior to 2013, when there was a broad, hey, they can vary it for a bunch of different reasons, you can kind of adopt an ordinance that tracks all of those things. It doesn't say that. It says you can vary it for these reasons. If they meet these reasons, you vary it. It doesn't say you can add a this isn't a reason or that isn't a reason or anything else. So first thing is that the parts about the economic value, at a minimum, or there's a good chance that they aren't part of the enabling legislation. Even if they were, the better way to read them is consistent with North Carolina law. And let me pass up, I think I've already handed you the Turek v. Surf City case.
Yes.
That was the one I handed up earlier.
Yes.
And on page 5 of 7, they start to talk about pecuniary loss as necessary hardship. And what they say is, in the context of zoning,
I'm
sorry, 5 of 7
Thank
and to 6 of 7 are highlighted.
Got it, thank you.
Yes, ma'am. In the context of zoning, pecuniary loss alone is not enough to show an unnecessary hardship requiring grant of a variance. Financial loss alone is insufficient to grant a variance, but it is a factor or an element to be taken into consideration and should not be ignored. To determine whether a parcel of property suffers from an unnecessary hardship, findings of fact and conclusions of law must be made as the impact of the ordinance on the landowner's ability to make reasonable use of his property. So you can't read the fact that economics are related to the problem that my clients have as a reason to deny a variance. If it meets the standards, you shall grant the variance under the statute. And let me hand up one last case. This is the Chapel Hill Title and Abstract Company down at Chapel Hill.
Thank you.
This is a 2008 North Carolina Supreme Court case.
Thank you.
And what's important in this case, this is the case that the facts are more important. The other one's the law, the overall concept of enabling legislation is more important. This one, the facts are important. So what happened here was there was an ordinance that kept a property from having, 75% of the property couldn't be developed. And then on the other 25% of the property, or it might have been 78%, but some large percentage couldn't be developed because of an ordinance. And the other portion, it couldn't be developed because of a restrictive covenant. And the Board of Adjustment granted, no, the Board of Adjustment denied the variance. I think the trial court upheld that, the Court of Appeals upheld that. No, the trial court reversed the Board of Adjustment, the Court of Appeals ultimately switched it back and said the Board of Adjustment was right. But the Supreme Court had final say, and they said that essentially, because there was no use of the property, no way to build anything on the property, you had to grant the variance. They sent it back and said the variance had to be granted because it met the standard of no reasonable use. Now, here's what, let me circle one way back. If you go back, Ms. Morgan complains about when I said that not only was there no reasonable use, but no reasonable value. What I was trying to point out was no reasonable use was a standard that was used that you essentially had to be in the situation that my clients are in to grant a variant, to get granted a variance under theory. Now, the practicality is I've sat with this board, I've sat with a bunch of boards, I've done this a bunch. The majority of variances get granted contrary to the theory. But this is the situation that variances were meant to apply. When someone could not do anything with the property, what the Chapel Hill title case tells us is that when that happens, there's no reasonable use. It goes past unnecessary hardship, which is the current standard, and goes all the way to the no reasonable use standard, which is the old standard, which the General Assembly said, we're going to make it so you don't even have to go that far to get an ordinance, to get a variance. But if you go that far, you certainly pass the new standard. And that's where we are. And that's where Chapel Hill title says you have to grant the variance. And there's also a concurring opinion of Judge Tyson, who, I think it was Judge Tyson. Maybe it wasn't Judge Tyson. Hold on just a second. I don't remember him being on, Justice Brady, I'm sorry. I didn't remember Judge Tyson being on the Supreme Court, but Justice Brady, I should have remembered, I clerked for Justice Brady at one point, was on the Supreme Court. And he pointed out that not only if they don't grant the variance, that it's unlawful and it's also a taking, and that the county would have to pay just compensation for that. And that circles back to the whole purpose for variances in general. And
Ben, can I ask you a question?
yes, ma'am.
So your contention is that Chapel Hill title supersedes the standards in 160D? That
No.
there's some sort of mandatory?
No, it meets
some sort of mandatory.
It meets the hardship provision. Although Chapel Hill title does say that if it's at the point, Chapel Hill title stands for the proposition that if it's no reasonable use, it's at the point of having to grant a variance. The variance is a little different in that case than it is now, and it was under 160 A 388 and a different provision, so it was a little bit different. But I think at a minimum, it means we meet the first standard, and it also goes to show why that language about no reasonable use and what was trying to be shown by that allegation in the application was not showing that this is all about value. This is all driven by the fact that there's no reasonable use, and that's what this case is about.
I just want, I understand if you're arguing that that gets you to pass ground one. That's what
It
I'm
might
trying
get you
to
a little
understand.
farther than that, but it certainly gets you past ground one. And
But you're not arguing it's a blanket rubber stamp to a variance.
no, not under the current ordinance. I don't think so. I mean,
Okay.
I
I
don't
just
know that
want-
the court wouldn't get there contrary to what I think.
I
But
just wanted to make sure I was tracking that, the argument.
no, but it,
Okay.
yes, but what it does show is, again, the pecuniary loss that the courts really are talking about is when somebody has to move their driveway, or they didn't follow a survey, or they didn't do this or that doesn't, it's, when you can't use the property, that's not the pecuniary loss they're talking about. That's the exceptional case that a variance is supposed to happen. That's what variances were designed to avoid, was the taking of property. And losing my voice again here. Let me look at one thing in Mr. Owen's big book here. I got a little thrown off. I was going to talk about all this at the motion to dismiss so that all this would already be in your head by the time I got to the end, so I apologize for having to figure out how to backtrack to it. So this is David Owen's land use law in North Carolina. It's kind of the Bible, I guess, of land use lawyers, if we had one. Maybe a book of the devil, depending on how you look at it. But what he talks about is the rigorous application of the no reasonable use standard. It allows a variance to be used as a constitutional safety valve to avoid what might otherwise be takings. And that's exactly what the Chapel Hill title case is talking about. That's what the purpose for variances is when you can't use a property at all, that's when a variance is really supposed to apply. And when they start talking about the pecuniary loss, I'd already given you the Turek v. Surf City, where they had relied on a survey to build a portion of their house or a portion of their driveway, and the neighbors showed up after they'd already built it and said, hey, that's over the setback, and challenged it. And what the court said was, all that is a true pecuniary loss. It's not a loss of use. You can still use the property for residential purposes. You can still do everything. All you got to do is take up the corner of that whatever you had that's over the setback line. But they said, even in that case, that pecuniary loss, they talked about it, it didn't matter. What mattered was the fact that there was an unnecessary hardship. So you have to read the pecuniary loss and the loss of marketability or more marketable portion of the ordinance consistent with North Carolina state law, consistent with case law, and consistent with the general statutes. And it can't mean that the variance can't be granted in the case where there's an economic loss. There's always going to be an economic loss, particularly if there's no use of the property, which is when the variance should be granted. There's always going to be an economic loss. And it doesn't matter what they're going to do or not going to do with the property. All that's determined by whether or not they can use the property or not. So, all that being said, we went through the standards of the ordinance with Mr. Kemp. And I'm going to go through them real quick with you again here. Mr. Kemp agreed, and I've just shown you that the alleged hardship is suffered by the applicant as a result of the ordinance. No question there. The hardship relates to the applicant's land, such as location, size, or topography, rather than personal circumstances. Mr. Kemp agreed it was funny shaped. Mr. Barr testified it was strangely shaped. It was different than all the neighboring properties. It had a number of different things associated with it. That land is definitely, and it was the land that drove where you took the measurements from that made it not a lot of record. The next one is the hardship is unique or nearly so, rather than one shared by many surrounding properties. Mr. Kemp pointed out that there were B, C, D, and F. And let's just forget about F. F actually was meant to be something out on the ocean front where everybody could hang out. It was out on the beach. But the others were plotted as lots. And he said there were two built upon. I think two of them might have been combined. I can't remember exactly. But either way, as I said at the beginning, something was done. There was a process they went through. One of them was recombined. One of them was granted access through another property, and that allowed them to build. This variance is the something that should be done with Lot E. And it is unique for what's existing there now. There are not, let's say there are 33 lots, 35 of them have been developed. F's never going to be developed. It is unique the way it sits. And the problem that it has is unique, because the problem, again, was driven by the triangular shape of the thing. That wasn't the same problem for the others. One was it wasn't enough size. The other, it needed access. Then we go to the hardship is not the result of the applicant's own actions. Again, you got to go back to the general statutes that says, even if they had purchased it with knowledge, which they clearly didn't, that can't be a reason. They had to have gone and built something that they knew was in the setback. That's the sort of thing that the variance, that language is trying to protect from, where if somebody goes and actively does something that then comes and asks for forgiveness rather than permission. And that's not the situation here. So 1, 2, 3, 4, 5, we met all 5 of those. Now we look at spirit, purpose, intent of the ordinance. I look at the provisions that he's pointed out there, and none of them really strike me as saying it's really that bad. You know, you're going to put in the same thing that's across the street if this is granted. And I don't see how that can possibly be against the spirit, purpose, intent of the ordinance. And it's also clear that there's no public safety issue. And this is the only way that substantial justice will be provided for my clients. And it'll be substantial justice for the neighborhood. Building this lot, you know, it's not going to be something that hurts the neighborhood. It's going to be a lot that's in line and similar to, or the buildable area of the lot. The lot will stay the same lot. It's not we're not asking for a subdivision here, but the lot will stay the same lot. But the buildable area will kind of match to what's there. So I think that the standards are all met. The testimony shows the standards are all met, and this is the exceptional case that a variance should be granted in. As far as conditions, I haven't asked Mr. Delaney, but I'll ask him now, would you be willing to have a condition that set the lot coverage so that it's driven off of the building envelope, not the entirety of the lot?
Yes, absolutely.
So, you know, that would be one worry that I think you might ultimately have, is that because it was a 40,000 square foot, that he could pack the whole 9,000 square foot full of house. But we're willing to set that at 30,000, you know, so that the percentage applies to the building envelope like it does to the neighboring lots. And also, I believe you would be willing to do a deed restriction that ensure that the rest of the triangle, the southern portion of the property below the requested minimum building line, stay open space.
Absolutely, yes.
So, I mean, I think that is another reason that solves the substantial justice. It keeps, you know, I talked with Mr. Kemp a long time about the intent of those plats, and I don't, you know, he clearly wasn't there, I wasn't there, none of us were there at the platting time and were involved in that process. So the intent is questionable. The only way to determine intent is to look at the documents, and I think that the documents are inconsistent about what the intent is, and that preliminary plat might not have been anything that ever went to a board. It might have been just, hey, this is what our earliest idea is. And even then, it doesn't say that they're open space. It says, or other uses. So if the county likes the idea of open space and this staying open space, and that's what they want, then I think substantial justice is served by keeping the southern portion of the lot as open space. And my client's willing to accept that as a condition. So I think the last thing I have to deal with is this question about what do we want to vary. And it's a good question. It's hard. It's not a one setback that we want to vary 1 inch, right? But don't think that it's uncommon to see variances that are based on a plat. And variance is just like anything, just like a deed. They run with the land. They stay with the land and they borrow it. I litigated a case in Nags Head. It's been a long time now, unfortunately. I'm getting older faster than I want to. But it was probably 10 years ago. And we went to the Court of Appeals, and the case was over a plat that they had gotten a variance of the plat that just said, your variance is you can build like this plat says in 1983, and they wanted to change it. And ultimately, they got denied because of a concept called res judicata. They had already brought it there and already shown what the hardships were, and what they got as the answer to the hardship was the plat that they had proposed that showed their building envelope and where they put things. So it's not uncommon to do it via plat. And in this case, it was the easiest way because, like I said before, there are multiple different things that could get you to this plat in terms of a variance. It could be, you could vary the modern day standards and you're granting multiple variances, or you could vary the 1971 standards that were used in 1974 as they were incorporated by reference into the language of the definition of existing lot of record. But either way, you end up with a result where we're asking to vary whatever it takes to get a minimum building line set at the 110-foot width with the setbacks that are shown on the property, on the plat. If you have any questions, I'll be glad to answer, if I can.
All right, county.
I'll switch with you.
Okay. The applicant is asking for a variance, but I'm probably confused just as much as you all are as far as what this variance is from. I think the burden is on the applicant to tell us what that is. I don't think it is the task of this board to hear this evidence and look at this plat that was made up, that was not, that did not comply with UDO standards, and you come up with what that variance is. I think that's very vague, and so that's my first point. So I don't think you can even argue each standard without knowing what the variance is, and I think the burden is on the applicant to do that, and I don't think they have met that burden for you tonight. However, there's still a few more points that I would like to go over. I'm not quite sure why we were talking about the enabling statute and the 2010 UDO or whatever that year was for. Our current UDO mirrors 160D. So I'm not quite sure really what the rationale was. We do not have in our current UDO the no reasonable use of property factor. So just to avoid any kind of confusion, our UDO matches that of the 160D, the current statute. So in looking at we thought the variance was from the definition of existing lot of record. And when you look at that definition, it refers to different ways you can find a lot as an existing lot of record. Well, it didn't meet several, such as a meets and bounds description or platted prior to 1965, I believe. So we really honed in on whether it met the subdivision regulations at the time, which is the 1971, and the dimensional requirements. I mean, that's the only thing that makes sense as far as what the variance is for, would be for those dimensional requirements. And in looking at that, if that's the case, you heard testimony from Kevin Kemp, the Development Services Director, excuse me. And according to him, some of these factors are met. However, in order to get a variance, which I will remind this board, a variance should be used very sparingly. It's not something that you just automatically get. It really is something that is rare. And it has to meet every single one of these factors. So the county doesn't, we don't argue that it does meet, I think, 4 of these 6 review standards. However, the biggest problem is that last one. The requested variance is consistent with the spirit, purpose, and intent of this ordinance. And you heard from Mr. Kemp as to that point and what those look like in our UDO and how this variance is inconsistent with that. And he testified that it is inconsistent with the following: compatible and efficient relationship among land uses. The lot was platted as open space. I know there's some argument from Mr. Gallup that we don't know what was intended, but we do see that preliminary plat does say, when you count up the acreage, it says parks and recreation or something like that. Better manage or lessen congestion in streets. Adding a home would, it would add at least one vehicle, and so that would add congestion, adequate open space between uses. So we don't know what the requirement back in 1971 was for open space, but that is a particular purpose and of the UDO as it stands today, and that goes right to that last review standard. Prevent overcrowding, and then the specific district purpose for the SFR that he read off to you. The district is intended to accommodate limited amounts of development in a manner that preserves sensitive natural resources, protects wildlife habitat, recognizes the inherent limitations on development due to the lack of infrastructure, and seeks to minimize damage from flooding and catastrophic weather events. So when you look at all of that, the county's position is this clearly does not meet that last review standard. So, and again, the application has to meet all 6. In addition, as I was mentioning in the beginning of this hearing, which I know I withdrew, but I had my motion, the UDO has specific grounds that do not constitute a variance. And I will reiterate that again. The fact that land or structure may be utilized more profitably or be more marketable with a variance, as well as financial hardship. So the evidence that we heard tonight and on the face of the application demonstrate that the applicant, they had this property for sale, they listed it, they had a buyer, and the buyer backed out when it was determined that this lot was not buildable. And so it doesn't appear to me as if they are trying to build a home and live on this lot. They're trying to seek a return on their investment, which is specifically what they say in the application, which I believe goes right to those two points that cannot be grounds for a variance. So that in and of itself, the variance should not be granted. There's also case law, and I don't have the cases like Mr. Gallup. He was more prepared. But according to Lee versus Board of Adjustment, the financial situation or pecuniary hardship of a single owner affords no adequate grounds for putting forth this extraordinary power affecting other property owners as well as the public. In addition, in looking at the plat that Mr. Barr created, and I guess that's what they're, Mr. Gallup says that they want a variance to achieve this. And so what that would require, it looks like just from, I mean, it would require several things, but I know it would require moving that building setback line. And I know Mr. Barr testified that that happens on occasion. And you move that building setback line so that you can meet the width requirement. But I wonder what is the purpose of even having dimensional requirements when you can just arbitrarily move this building setback line? It makes no sense at all. So I would completely disagree with that. So again, the county recommends denial of the variance for several reasons. It doesn't meet all of the review standards. And it also constitutes grounds that cannot serve as grounds for a variance. And I think that's it. So, all right. So we would recommend denial.
All right, thank you very much. I'd like to take a 5-minute break, please. All right, we are now back in session again. And I'll open it up to members of the board to, let's hear what you have to say about what we've heard tonight.
Let me start.
Sure.
Well, I think Mr. Gallup has made a compelling argument. And I'm looking at these six elements, and I see that, in my opinion, this request meets them, you know, I mean, and especially the very last one, substantial justice is achieved. It seems like that, you know, that this lot is not ridiculously out of variance. I mean, it's going to be a single-family house. I mean, I think, just my opinion is that if Mr. Delaney is willing to make those two conditions, it's just not that far away from what else is there, and that's just my opinion on it. And yeah, of course, and Ms. Morgan pointed out, you know, about financial hardship or more profitability. Mr. Gallup also pointed out that any change like that would affect profitability from it.
Yeah, I agree. You know, the financial hardship, profitability, you know, is kind of what I was getting at the very beginning of this hearing. You know, you can have two things be true at the same time and not necessarily negate the other. You know, there's inherently going to be some financial impact when a piece of property is rendered of no value based on its configuration, its dimensions in the ordinance. So, you know, this board, we really are only here, we really have to adhere to the 6 standards. You know, that's the only thing that we can go by.
And of course, again, it goes back to exactly what is the variance that they want, you know,
Right.
that
But
we're voting on here.
That's the other part. So I think we can probably pretty easily, after the testimony we've heard tonight, kind of go through the 6 standards, and it's got to be all all six, right? You can't be 5 or 6, can't be 4 or 6, you gotta meet all 6, right? I think that's a fairly easy conversation to have. To me, the hardest part is the conditions, right? Because if we're gonna grant a variance, you know, what are those conditions that we're granting? And I think that's where I'm kind of struggling. I mean, I can visualize it on the plat. You know, I can look at this plat and say, okay, this looks like a reasonable sized lot
Right.
with reasonable setbacks. But, you know, I would want to see the conditions spelled out exactly, you know, where these lines are, what these setbacks are. You know, you can kind of look at the plat and, you know, get out your ruler and kind of estimate. But I would prefer to actually see those conditions in writing as a condition.
Help me understand what
Square
you're
footage
talking
of the
about.
house.
I'm talking about, so if we were to say, go through the 6 standards, right? We gotta get through that. Say we get through the 6 standards, we all agree that, or 4/5 of us agree that the applicant has met the 6 standards for granting a variance. So that's only half of the equation, right? So we grant the variance, but we're granting a variance with conditions. What are those conditions, and what do they look like? I mean, all we have right here is a plat.
And what is the variance? So my caution
Right.
to the board, not in terms of swaying a decision or not, is that you need to, because you need to identify what you are varying, because while there may have been a case where there was a blanket variance, my recommendation to this board is that if you want to spell out from looking at the plat what you are varying based on this, and we can work through that to make sure we identify what that is. My caution to a blanket variance, which is just like, yep, they can build, according to this plat, is all the other phases of development and building review that have to occur through the county in terms of the siting of a structure and septic and all those other things that may not be anticipated here. We got to know which year rules they're developing under. I guess I understand that the applicant's asking for just anything and everything. If it comes up, you have stamped our variance.
Make it better.
But I think you have to decide if you're going to grant a blanket variance, or you're going to say, we are going to vary these terms, and we want these conditions as well.
Right, and that's kind of what I meant about the conditions discussion, like what does it look like? You know, it's one thing to go through, you know, we can say, and maybe this is a question for the applicant, you know, is your variance to the determination that the lot did not meet the definition of a lot of record? You know,
So I think
So that
he's,
solve
and
all the
he's gone
issues.
over this a couple times, and I think we are having a probably more of a legal disagreement about varying from something that you guys have already decided. But I understand he's saying, but we have to vary because you've already decided this. My biggest question about the variance is if the only variance is we're gonna vary you from the definition of an existing lot, well, there's standards in that definition that you have to meet in order to do that. So if you're varying from a certain portion of that definition, right? So assuming you're saying we qualified under the 1971, or fine that we do, or just vary from the current ordinance that requires building setback line, and it would also have to be the width as well.
So, the
If I could-
details of the technical side,
I was going to say, if I could offer a practical way to look at how that might work, like you said, we got to get through the vote on how it's all going to work. But at some point, somebody's going to draft an order And that's going to have to come back to you, kind of like the minutes that were in front of you tonight. And, you know, essentially we could draft an order that varies the right things to make the plat right. You know, it attaches the plat and says, you know, granting a variance consistent with this plat, and then spell out everything that has to be varied to meet the plat.
But and I guess that's where I go back is you're asking them to do a blanket variance, but they're not, what's before them, they don't, and then you're like, okay, well, we'll vary everything, but what if it comes back and they're like, well, we didn't know we were gonna have to vary that. We didn't know that you were asking to change this. And so the board has to consider those things in order to vary. And that's my point, which is, you could say that, but then what happens when you guys come back and there's a list of 10 items that they had not considered?
A normal variance that I've seen, there's a specific provision in the UDO or something that the applicant is seeking a variance for. And here we don't really have that. So it creates a situation where we have to form a whole set of conditions, right, that would be binding along with the variance. And I don't know that we have all the information to even be able to do that.
I think Ms. Morgan hit it on the head, was that it's not our function to have to create all of these variances. It should have been spelled out in the application about what particular sections had to be changed in order to fit this proposed site plan. It's not our function to have to create all of those, like moving the front building line up, or changing the direction of where the driveway has to come out, or numerous other ones that are going to happen from having to attempt to make the plan that Mr. Barr has drawn to make it work.
I think that while there are things that are maybe that are not spelled out specifically about what could be granted to meet this, I think that it's been clearly established that they are requesting a variance to move the building setback line. That's a clear request in the ordinance, a variance from the ordinance. They've also requested a variance from the minimum lot width from 125 to 110. Those are two very clear variance requests that are set forth here. They've also said we will agree to conditions that say we have to build within the building envelope here, right? So like in terms of proposed conditions. So while there are things that maybe, you know, I'm saying like the driveway. Well, he said, look, I think the driveway can be flexible. The staff said, I think the driveway can be flexible. You don't have to address that. And if it's not addressed, then they have to comply with the standards in the current ordinance. So you can identify the things that you feel like you are aware are requested variance pieces, and then say the rest of it you have to comply with the ordinance. Whatever today's ordinance, I think is what they said. Make it today, make it 1971, whatever. So the rest of it that you don't know, you can require as a clear condition that it comply with the 2023 ordinance, but it's not 2013. 13 is the most recent.
13.
And whatever today's ordinance is.
Whatever, the most current standards in the ordinance is my point, is that, so that you're not, you know, you can grant what you know has been requested that you feel is appropriate, and then if it's not been presented, then you don't have to address it, is what I'm saying.
Ignoring the 6 standards for a moment with you, I don't have a whole lot of huge issues with the plat drawing and the changes in it.
I don't either.
And maybe that's because of what I do. But, you know, I'm certain it is because of that and the background of those things. And what Lauren is expressing is absolutely true. The things that we don't define, if we were to create a variance and allow that and say, okay, this plat with conditions X, Y, and Z, you know, 1, 2, 3, however that stamps out, those conditions would override anything else says. You got to do this regardless. That's what they said. Too bad. You agreed to it. This is it. It rides forever. But the other things that aren't there, like how far can you put a driveway from a corner? You know, what kind of setbacks? How wide can the driveway be? You know, all that kind of stuff is already in all the details that Mr. Kemp and his team deal with on a daily basis. So when you pull a permit and you do, this is a plat, this isn't a site plan. So it's not gonna show you a house.
Right.
And it's not gonna show you a septic system. And it's not gonna show you where the well goes, or how wide the driveway is, and all that kind of stuff. All that stuff is in the ordinance. All that takes care of it.
But which ordinance now?
You
We're
do-
gonna deal with
it-
1971.
Current, when you pull the permit, you have to follow those ordinances. Okay, you have to follow those setbacks. If the setbacks change, you have to follow those. That all comes from the current ordinance. That's not some of these other things, okay? So a lot of that stuff, a lot of that stuff is, you really don't have to worry about is what I'm getting at.
So we're really just talking
So really,
variance from lot dimensions.
right.
I think that's part of what you have to
The-
decide,
the
because they've
biggest
asked for a
question-
blanket.
The biggest question, you know, for us, for my piece, we can talk about all the technical stuff all you want. That's easy. The harder thing is there a variance to be provided or not, and is there justification for a variance? That's the first question. If the answer to that is no, then
All the rest
just
doesn't matter.
put this in the trash.
Yeah.
So why don't we get over that hurdle? Because that's the elephant in the room to talk about. And then let's get on with, if there is something, let's talk about the technical stuff. If not, let's close out and go home.
Yeah, and I think Robin kind of started out his comments, kind of laying out his thoughts that he feels the applicant has met their.
My point was what you said. I look at this and it doesn't look like an unreasonable thing to ask for.
Yeah,
You know, to have a buildable lot there,
Right.
you know, now.
It looks and feels about the same size. It's about the
Exactly. It
same
doesn't look
size.
like
It's all that
it-
kind of
it's
stuff.
ridiculously
You know,
different.
it goes sideways instead of front to back. I mean, that's really the biggest difference. I mean, for all intents and purposes, if you swap, you know, length and width, and you essentially move the building setback line because you got all this additional other property, it's really not a whole lot different than any other lot over there that you compare it to. But
And that was my point, yeah.
but the question is, should the variance be provided or not? So why don't we work through that, and then let's work through technical stuff if necessary. You guys in agreement?
Yeah, that'll work.
Okay.
Mr. Chair, may I ask a
Yes.
question on, Mr. Barr, do you think anybody's going to have any additional questions for Mr. Barr? Or can I release him and let him head back to Dare County?
I don't think so, do you?
I don't see any.
No, I don't think so.
Thank you, Mr. Chair. I'll let him go. Thank you very much, Board.
Yash wants to leave?
It's so much fun.
No need to leave now. Fun's just getting started.
so I guess we could do this one or two ways. We could go through each of the standards individually, or.
Yeah.
I think for the
or-
record, it's
have to.
important that we do that, yes.
Yeah, you have
So-
to go through each one.
Why don't we start with the first standard? Okay. And we've been,
Alleged hardship is suffered by the applicant as a result of the application of this ordinance. I think
That's true.
That's, yeah.
I think, yeah,
Is there a motion?
I think I agree with that.
the ordinance.
Well, we're just discussing that.
Oh, okay, I'm sorry.
I think at the end, we'll
Go
take them
through
one
it.
by one,
Okay.
go through the
Yeah.
motion process.
Understood.
So, yeah, I mean, the
Looking for
ordinance is
consensus.
what we're dealing with, you know.
Yeah, but again, you know, I mean, and it says you don't necessarily need to know that it doesn't conform, but, you know, I mean, that's something to also think about, you know, I mean, why didn't they ask? When did they find out before they bought, you know?
To be honest with you, these kind of situations are some of the most difficult ones that we have and the ones that I dread the most.
Okay.
Because I understand how we used to do this years ago, and we didn't do a good job of it. And we ended up with situations like this where we got lots A, B, C, D, E, and
Yeah,
F.
you know, I mean, when they
And-
originally did them,
and-
they could have just said,
And we
"I
don't
care
know.
what happens to those.
I mean, and I'm just trying to be fair and be honest with all this discussion, but we don't know when and where this came from, and it doesn't get recorded. Now we have TRC, and it goes through, and you have a preliminary, and you compare the preliminary to final, and you say, are these reasonably close to one another or not? And what are the substantial changes? Are they significant enough that needs to go back through or not? No. Okay, it's good. And we clean up all these sins of the past. You know, and you say, well, was it bought before 1965? April 2nd. We all know the day. I mean, it's like grained in your memory if you do this kind of stuff because of those kind of things. Because there's a lot of issues, and we did things so informally. We didn't have the good record keeping, and it creates these situations. So that's why we're dealing with it today, just because of the ambiguity. I don't think we'll deal with it from 2000 or then on, but there's stuff later, we didn't do a good job. And that's why we're dealing with it today.
is
So I hate
everyone-
these situations, but that's why.
Is everyone in agreement that number one has been met?
I agree with that.
I agree.
Okay. All right, what about number two?
The hardship relates to the applicant's land, such as location, size, topography, rather than personal circumstances.
And I would
Yes,
agree with that.
agreed.
All right, number three?
Hardship is unique or nearly so, rather than one shared by many surrounding properties.
That's true.
Yep.
All right, number four?
The hardship is not a result of the applicant's own actions.
Agreed. He didn't plat it, didn't record it, didn't any of that.
All right, number five?
The variance will not authorize the initiation of a non-conforming use of land. So it's already zoned single-family residential.
Single-family residence, that wouldn't change, right?
Right.
I agree with that then.
All right, and the last, number
The
six?
last, the requested variance is consistent with the spirit, purpose, and intent of this ordinance, such that public safety is secured and substantial justice is achieved. Now this one is one where I'm looking at it, I'm flipping it around, looking at it from the other side, right?
Let's do that.
So we have a unified development ordinance for a reason.
Right.
Right? It's to protect public safety, public health, public welfare, right?
Yeah.
The community. So I'm looking at this from the other side. If this lot is developed, how, when, and why does it harm public safety? Is it a detriment to public safety? Is it something that's going to cause a problem in that community and in the county at large? Right? It's, so when we talk about the spirit, purpose, and intent of the UDO, we're talking about protection.
Right.
And for me to answer this question, I would need to understand how this development would harm the community. I don't see that it does.
I don't see if you build a single-family house on this property that it would harm anything.
And I sort of agree with that. And again, we'll go back to, and substantial justice is achieved. I mean, is it going to be, if we deny that, you know, and this lot remains completely undeveloped, unbuildable, we can put nothing on it, is that justice? In my opinion, I don't think so.
Well, no, I'll take the devil's advocate too, just so we can have the record piece. Why the setbacks there? For safety and well-being. So, you know, for fire protection, those types of things. So if you made the argument and said, well, what about the hazard of fire? Well, it's the same setback as the one next to it. So is this lot more flammable than the next lot? Apparently not if you maintain the setbacks and do those types of things. Otherwise, those things would get changed. And that's why we have ordinances for that health and well-being. If you went back and you took a look at this and you said, well, this plat here says it's supposed to be parks and other land usage. Okay, so we talked about the vehicles, and you take the vehicular, and I'm not a traffic study expert, but I do have experience in this to some degree, and I think you all are reasonable people too. So if you had one house there, in your own mind, don't answer the question, but in your own mind, you know, think about the traffic that happens with a house. If you made it a park,
A lot more traffic.
is the traffic more or less?
More. In degrees.
In degrees, right?
Yeah,
Right.
it's in degrees, right?
Right, so, you know, at the end of the day, if you followed that and said, well, it should be a park, and you want to take the traffic route, you know, I think you're actually going with a less severe action, putting a house on it.
Plus we don't have no idea what the intent of whoever wrote that is. You
I'm
know,
just-
it could have been, well, I just can't figure out what else it should be. It doesn't look like a buildable lot, so we'll make it open land. you know?
I'm trying to be negative and take the other
Yeah,
side.
yeah, but just saying,
And just
we're
to,
just
you know, make
discussing.
sure that we're being, you know, fair to everyone in those pieces. You know, and if you talk about the harmony and the public safety as well. Mr. Craddock, Chairman Craddock, how many people signed up tonight for public comment?
0.
How many people even came to watch it tonight?
We have
So-
a couple here, that's it.
Well, but they're part of
Yeah.
the process. No one from the outside is not involved with the process. So, you know, from an argument of, and we do hear these things from Corova, the roads and different things like that. No one was clear enough to even come here and make that comment. Yet, you know, with the applicant came from Florida to talk about it because it was important to him and his family. So, you know, I'm a big believer if you've got a problem with it, you should be here and you should say something about it. Don't come after the fact and tell me you're not happy about it. And no one came tonight. So that says a lot to me about what the community thinks about this. So I'm really struggling with how it doesn't. To me, I think the last point, it's meeting it.
Yeah, I think it does too. That's why I was saying kind of from a reverse, you know, when you look at this in the grand scheme, in the context, where it's located, how it's in the same zone, the same single-family residential zoning as everything else around it.
Right.
You know, how is it harmful? I fail to see how it's, this particular lot, this situation would be harmful to the community at large.
I agree, and Kathy made a good point, you know, if you turned it into a park, you know, then you had 10 times the vehicles, you know, traffic would come through there.
Definitely more. How's that?
Yeah, okay, definitely more.
But just as a reminder, for the record, we did not hear from a traffic impact expert
Yes,
about
ma'am.
traffic
This is a
impacts.
dirt- a
Either way, good,
sand road,
bad,
though.
ugly,
Also-
otherwise.
also it's gonna be
We heard
pedestrian.
about the width of a right of way for emergency vehicles to transport.
And as far as widths on right-of-ways in subdivisions, which I deal with all the time, is 60 feet is standard.
And that's what's on there. It's
Right.
30 feet on each side.
Yeah.
60 feet.
That's correct. It's typically a 20-foot lane and a 15-foot utility easement on each side. And that's what that's prepared for, at 60 feet. That's why it's that number. All right. So number 6, anybody in disagreement?
Yep,
Nope.
yeah.
You are? Please, I mean, because we're here.
Oh, yeah,
You know.
I'm good and ready to tell you.
Awesome.
When we look at all of these other, and we've already adjudicated that particular matter the previous time that it was here. When you look at all of these 33 lots, and you look at the other ones that were labeled as letters of the alphabet instead of numeric, none of those had setbacks on them. I believe Lot E was meant to be, just as the preliminary plat said, that it was going to be park area, it was going to be what we now call open space. I really don't believe that it was intended to be a buildable lot. Why would a developer, when they created a subdivision, label other lots different and not have the setbacks on those lots if they intended to sell them as buildable lots? That's my opinion on that part of it. It doesn't make sense to me.
No, I understand what you're saying with the drawing the pieces. The challenge for me is, you know, I look at it and I hear all that too, and I'm kind of like, but I'm struggling with it because we do such a, and I know this from experience, we and other municipalities across the country have all done a horrible job of doing this, and they've created these problems, and we shouldn't even be here dealing with this, but we are because the paperwork wasn't clear and the records weren't kept, and it was just kind of informal sometimes.
Yeah, the recorded plats were not clear,
mean-
but our UDO is clear.
But they're not in the same time period.
No.
So, you know, how do we take what we have today in 2013 that we use today in 2023, and then we lay that over top of something that was done in 1970?
And when the subdivision was created, it was created based upon the 1971 UDO, and evidently it must have been in effect and passed with
Right.
that.
But it also-
Was there an open space requirement in 71?
Oh, I don't
We
know
never-
about
we
that.
never
We-
established
we-
that.
And it wasn't even established, and nobody took the time to even present it to us. You know, and even on this thing too, I hear you, the parks, but it says parks and other uses. What are the other uses?
Right.
It doesn't say other uses than houses or other uses than, it just says other uses. There's times when we develop subdivisions, and we do it in phases. And as we do that, we take a section and we may label it as a section or a phase.
Yeah.
To me, that's no different than a letter was then. And I look at that and say,
I think most of the time now, though, when something's developed, that there is also notification on the plat that says future development.
Right, but again, we didn't.
Not here,
We didn't do
right.
that, and we don't even know if that was really reviewed. There's plats that I drop off when I come into the office too.
Well, and I think that just in regards to the, kind of the evidentiary standard, or kind of what you guys would consider there, is one, this is kind of a unique situation, because you have already previously determined it's not a lot of record, and there were a lot of factors, including the lettering of those parcels, the preliminary plat, the final plat. You already went through that, and you rendered findings of fact and made a decision about that, and what that meant, and how that, what that is. So your discussion tonight is not really questioning I think maybe the purpose of the lot. I think ground number 6 is about, is it consistent with the area, I guess is kind of the way I would describe it, and consistent with the ordinance in the sense that you guys are saying the area, right? The other areas of this development. So I just, and I think that clearly, based on the discussion, that some were persuaded, based on the reasoning in terms of being that last ground consistency, and others were not, based on the prior case, which is fine. I mean, but, we're not relitigating the purpose of the lettered lots on that plat, because you guys have already done that.
Well, I thought what we ruled on then was whether Mr. Kemp's letter was correct, whether it was,
And the basis of that was through those evidence that was presented to you through those letters. So we're not relitigating. You don't have to agree, and I guess my point is, you don't have to agree and decide on the purpose of the lettered lots. The question before you tonight is, do you feel like the variance requested meets that ground? And it can be for a number of factors. You don't have to, you're not relitigating the purpose of the lettered lots. That's my question.
It's really more, if not for the dimensions of that lot, how would that lot differ from any other lot in that neighborhood?
The first time around, we didn't have that plat that Mr. Bohr has done up. And we had a lot of questions about, could you put something here? Where
right, I
is
remember, I
this in
thought about that too,
reference?
Kathy.
And having this, for me, solidifies that that area is buildable. You can put a decent-sized 3-bedroom, 4-bedroom home there and not disturb everything else. And I think it would make sense. It would be more in the spirit of the whole area that it's in. It would be just like the other homes, the other parcels all around. It wouldn't be an oddball.
Right.
So with me, I'm glad that they had this. 'Cause if it was
Should we go over
presented
the-
like it was last time.
Well, I don't
Five-
know, was the chair finished with his comments?
Yeah, I believe so.
Should we go through the
Pretty steadfast
five
where
factors
where
that,
I'm
That's
standing.
fine. I just know if you wanted to have more discussion about.
Not on my behalf, but if the other board members do, yes, sure.
I'm gonna start on with one thing here too. And give me a second on it too. Where are you pulling your variance list from, of the 6 conditions and the language around those 6 conditions? What
Right
page?
here,
Right here.
13 of
There's
42.
13 in the packet.
Okay, all right. So I look another place and we have it,
It's a little different.
yeah, the language is different,
It is.
and,
That needs to be updated.
yeah,
But
that's,
the other ones are the correct version.
that's what I'm.
That's something we can talk to the clerk about later,
Yeah.
about an update there. So we can absolutely say between 1 and 5, all of us are in agreement that they did meet that.
Yeah, and like I said, on 6, I keep coming back to, this whole discussion has been about lot dimensions, right? And if not for the unusual lot dimensions of this lot, how would it differ from any other lot in the neighborhood? Right?
yeah, I mean, you look at the total square feet, it's twice as big as the other lots.
And because it was residual type at the time that the subdivision was created.
truncated version is comparable in size to the other lots in the neighborhood.
You think we should go through the 5 factors that do not constitute variance?
Depends on what his comments will
Okay,
be
yes, right, we're waiting, Sam.
on the other issue he was having.
You can go ahead and take a look at the 5.
You're gonna do that?
That's fine.
All right. Let's do this. Would it be logical to have one motion that incorporates all 5 of these, being that we know we're all in agreement on those? And then have another one
It's an all or
based on
nothing.
that?
It's not really, it's an all or nothing.
I would prefer you go one at a time because
Okay.
that's the better record keeping and there's no question
Okay.
about which ground. And so we could quickly go through the first
Okay.
5 and I know that you guys agree, so if you can get a first and second, but I would prefer the record do it
Okay.
that way.
All right, well, are we, would you like to make a motion, Troy?
Yeah, I'd like to make a motion that the alleged hardship is suffered by the applicant as a result of the application of this ordinance.
And I'll second that.
All in favor, say aye.
Aye.
Aye. All opposed, nay. Motion passes unanimously.
Just keep on going.
Go ahead, bro.
I'd like to make a second motion that the hardship relates to the applicant's land, such as location, size, or topography, rather than personal circumstances.
Second.
All in favor, say aye.
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 All opposed, nay. Motion carries unanimously.
All right, I'd like to make a motion that this hardship is unique or nearly so, rather than shared by many surrounding properties.
I'll second that.
All in favor, say aye.
Aye.
All opposed, nay. Motion carries unanimously.
All right, I'd like to make a motion that the hardship is not the result of the applicant's own actions.
I'll second that motion. All in favor, say aye.
Aye.
All opposed, nay. Motion carries unanimously.
All right, I'll make another motion. This variance will not authorize the initiation of a non-conforming use of land.
Second.
All in favor, say aye.
Aye.
All opposed, nay. Motion carries unanimously.
All right, and the final motion,
Hold on just a moment, Troy. Did you want to go ahead and make any comments about the other issue you were thinking about? Before we go with this last one, was it in relation to number 6?
It is in relation to number 6, and the substantial justice achieved. I hear the financial hardship case, and what Ms. Morgan has presented. And I, on the surface, when I first hear it and I first look at it, yeah, I get it. I kind of like, why are we even talking about this, And then, we hear from the applicant under oath who testifies to us and says, look, we bought this thing in 20 years ago. And, I'm 65. Thereabouts. I apologize if I got that wrong.
Nearly.
We'll go like 63. We'll make it better. Okay. All right. Looks like he's 63. All right. In any respect, life changes. And I can recognize the fact to say, at some point you're like, what, I don't want somebody to have to deal with this, and I want to dispose of this and execute and get out of it. And I've paid money for it, so it'd be nice to get my money back. And if I could get something for it, because it didn't do anything, great, but I'm just trying to get out from underneath this. So, when I look at those kind of things, I don't see it as a big developer. I mean, they're a retired couple almost, working part-time in Florida. And I just don't see it as somebody who came in and bought it and said, look, I'm just trying to do a proposition to make some money. I just don't feel it. And under his testimony under oath, that's how I feel about it. And when I look at it and you put the words in there to say is substantial justice achieved, I just in my heart can't sit here and say that substantial justice is achieved by those things, knowing that as a municipality, which I'm part of, we didn't do a good job documenting things. And because of that, people made bad decisions based upon that. And they're in situations like he and his wife are that they shouldn't be in. And the realtor made a bad decision. And the planning staff that did this work didn't do a great job on it because our ordinances weren't in good order. And they made a bad decision about it now. And now it's like, it's yours to take it on the chin. And when I sit here and I say, you know, we have the ability to, in my eyes, have justice in those things to allow them to do something with the property where it's not like, you know, hey, they're going to make millions and retire, but they're just trying to get rid of it. To me, that's substantial justice. And that's the thing that I struggle with when I got to go home and deal with it. So that's what weighs on my mind and my heart right now with it.
And I agree with that.
So before we get to 6, that's what I think about that thing.
And I just want to note about.
And that's not a, and let me finish, please.
Oh, I didn't know you were.
That doesn't remove the fact of the financial benefit either. Or say that, you know, hey, this is for, you can't do this because it's a financial hardship. I don't think it's a financial hardship. I mean, at the end of the day, if they can sell a lot or not sell a lot, are they going to be able to retire or not? I think they'll probably be okay in life. But it's just a burden to get off, and I think it's fair and equitable to people. And that's just what I feel about this situation. I'm done. Thank you.
Oh, that's fine, and I did not mean to interrupt you.
You're fine. I just
I
was,
took the calls probably too quickly. I just wanted to note that obviously my part of my role here is to, you know, look out for the decisions the board makes. And the decisions you guys make are you're supposed to apply the ordinance consistently, right? And you get people who come ask you for variances all the time, and they're like, one I can think of is was it the sunroom? Where the sunroom was added on, and it was like 6 inches or something. And like, you know, unfortunately you found, you know, and they're like, you know, it's gonna cost us all this money to move it, and that does weigh on you. But I think that this case is actually unique from that case because when you're talking about the financial piece, is that in that situation, they had the use of their property, and in this situation, unless the variance is granted, they don't have a use, so they can't even like put up a shed, or you know, they couldn't put up a I don't know, a swimming pool. Just whatever. They can't do anything.
except pay the taxes.
On this, with this property, except walk on it. So I think that in terms of the value piece, right, the financial hardship piece, that this is a unique situation than other variances where it is gonna cost somebody some money to come into compliance, and we're like, well, we're sorry, you should, you know, that's what happens.
After the fact.
Yeah.
That's right, so I just wanted to point out this is different in that regard.
And I feel that way too because of that as well, because there's other cases too, and there's property that I've personally purchased as well, that, you know, we hoped it was a lot of record and it was legal and stuff, but it wasn't. And it was just too narrow, and there's nothing you can do with it in those types of things. You know, and you gotta combine it with something else or do something else with it, and that's all fine and good. So if this was like some ridiculous strip of land and it's like, oh, you know, we can't, come on, you didn't realize you couldn't put a house on it here? I could see on this one where you could see and feel that from the very get-go, regardless of what Mr. Barr has done or others.
Yeah, I
I mean, if you walked out there and looked at it.
Yeah, you say,
I
yeah,
get
the house
there,
would go over
yeah,
here. I'd do it
exactly.
like this. I'd lay it out like this, you know?
There's clearly a buildable portion of it.
Right, from a technical standpoint.
Technical standpoint.
Right.
Yeah.
When you come in and it's 20 feet wide and you say, oh, I didn't know. Yeah, come on.
The more unfortunate part is that they made the purchase without having known. That's the more unfortunate part.
It is, and we don't have a good means to inform people of this. They show up here at this situation because they've done it and they've spent a lot of money in some cases, and then they're stuck.
Just like it is, it's caveat emptor,
So,
buyer beware. All right, you ready, Troy, to
Are we
to
ready?
do that?
yeah.
Any other comments about number 6?
I think I'm ready to make a motion.
Yeah, go ahead.
No more comments on number 6.
Yeah, go ahead.
All right, I would like to make a motion that the requested variance is consistent with the spirit, purpose, and intent of this ordinance, such that public safety is secured and substantial justice is achieved.
I'll second that.
All in favor, say aye.
Aye.
All opposed, say nay. Nay. The motion carries. 4 out of 5.
Okay.
Now you have to work on
The technical
the
side.
technical aspect of the variance. I took some notes on some of those things.
Okay. Looking at the 71 standard, would you want to get started or you want me to get started?
No, I'll give you the ones that I wrote down here.
Okay.
And
the 71 standard too?
I do.
it appears,
Basic standards anyway.
it appears that what they were asking for was moving the front width line up to the 110 mark on that drawing that Mr. Barr did. Mr. Barr also mentioned a logical solution of the driveway would be to be on Sandpiper Road, which seems logical
Well, it's consistent with things too, and I have illustrated examples
with
of
all
that
the
as
rest
well.
of the properties are on that same street.
Well, we do it all the time on a corner lot.
On a lot, you just choose which way you want to go.
Well, you do and you don't sometimes, but yeah.
And also changing the front side to the east side instead of the south side on Seagull. That would then be the front side of the property.
The front of the property,
If the driveway typically is coming,
Do we need,
I
do
didn't
we
hear
need
that.
to? No, he just said that would be the most logical.
that would be
place
logical if
for
the driveway's on that
Driveway
side.
entrance, not that that would
Yeah.
now be the front. The front is still the 110 side.
Well, that depends on what we allow him to do.
well, I think if we, as a suggestion, if we define that access needs to be maintained off of Sandpiper along the 130, 131.6 foot
The
side.
northern line.
Well, it would be the eastern side, actually.
Right.
Yeah, Sandpiper's along.
Right.
So if access had to be acquired to the property from the east, that front, back, side, to some degree is really irrelevant.
And is that something that would be covered in the ordinance already?
Well, it would be, as a suggestion, the western setback line is requested at 20 feet. Okay?
Right.
Now, use of the property, you have those types of things. To make it just clear, so it's as equitable as you could be, say somebody said, well, that's really the back of the property. Why is the setback 20 feet instead of 25? My suggestion is that we make that setback 25.
Well, they got the northern
west
boundary
side.
is 25.
Well, I would suggest that we just leave it there to be conservative. There's some wetlands there anyway and stuff like that. 5 feet isn't going to make a grand scheme of things in putting a house up in a septic system. This area is going to have a very high absorption rate, so you're not going to have a big septic. It's all sand, So when you dump the water on the ground, it goes away pretty quickly.
So you're saying 25 feet on the western line
I would suggest we make it 25, just to make it clear.
as
And
well as the northern line that's already
And all the others
25,
remain,
and then 20 and 20.
yes. So,
So that means that front, the building setback line would be at the 110 mark. And then the other setbacks would be the 25 on the west, 25.
my
On the
my
north.
suggestion is to use the plat that Mike has drawn with corrections.
Okay.
And the correction being the western setback being 25 feet. All other setbacks remain the same. That's one. 2, access from Sandpiper.
Yep.
Okay? And all the driveway stuff and those elements will all be covered, under the UDO and those pieces. And my suggestion, to make this very clear so that it's extremely equitable to everyone, is that everything south of the 110-foot width or 110-foot dimension, however we want to potato.
Setback line?
Well, it's, yeah, whatever that 110-foot width is there, that dimension. There's not an extremely good way to describe that. Basically, everything south of that be restricted from any and all construction.
Other than septic.
Well,
No, even including septic. Put it on,
he said that you could put the septic out there.
he's talking from a technical standpoint.
Yeah,
I'm talking,
about from
I'm talking
developmental.
about, I'm trying to make things fair, equitable in those pieces. And when I look at the other lots over there,
Yeah, they're
across
all
the
within
street,
that.
they're about 20,000 square feet.
They're all
okay?
within that. So
And it's,
use
and it's
their-
all within that space. And you do have to, Mr. Barr, I believe, made an error, and I'm just remembering from what he said, septics do have setbacks.
Yeah.
You-
Yeah, they do.
You can't put them right to the property line. So they have to follow that, and based on your fill requirements, it's all based on your fill requirements and other things as well. And in the rear, you have to maintain outside the 25 feet as well. So there's rules with that, and it's all in the ordinance. But there are setbacks, so you can't just put it anywhere you want.
So south of a 110-foot line, no development whatsoever?
No development, building, no sheds, playhouses, et cetera. That's just purely gonna be open space forever and eternal. Knowing that I'm not the smartest person in the room, what I would like to ask of my colleagues here as well is that being intelligent with this, it would make sense to consult with someone who does know the ordinance very well, Mr. Kemp, and ask him, in his professional opinion review, being as that we are going to grant a variance and those types of things, are there any things that you think we're missing, that you think we should look at relative to this, and how to do this? So it makes your job and your team's job easier in the future. We want to try to get it right once, rather than have to do this.
One thing that has come to mind is you're going to grant this variance. The logical thing to do would be for them to record the lot, make this a legal lot. If that's the case and we're basing it off today's ordinance and today's standards, I would suggest a variance to the lot size as well, given that the minimum lot size currently in the SFR is 120,000 square feet. So you could take that, give a variance to the lot size, given what the lot is, not the building area, but the entire lot.
Yes, sir.
I would suggest if you are going to approve the variance to do that as well. That makes it very clear when they go to record it.
Okay. Can you assist specifically with how that language should be prescribed?
Is it the minimum lot size?
Yeah, I think it would be as simple as a variance to the minimum lot size, and then the dimension of the lot, which 41,880.
76, yeah.
76.
Seven-
To record it,
876.
876.
yeah, when you say to record it, it's recorded as Lot E. Does
Right.
that change, and it has a PIN number? Does all that
Well,
change now, or?
No, it has a PIN number. What will happen is they will record it. It'll be, they'll record it with the office, the registrar. It becomes a legal lot, and then, from there, the county will assign it an address and take it from there. The first step is just to make that a legal lot, to get that on record.
Part of the fixing these problems is recording a new plat in a lot of cases.
So that's something we should definitely vote on.
Yeah. I'm sorry?
That'd be part of a
Definitely
motion,
we
yeah.
should vote on.
Well, it's,
Yes.
yeah, we need to talk about it, but my strong encouragement in doing this is that the gentleman knows how this should be. So if we're going to fix it, let's.
Keep from having to come back later because of an error.
Right, and
or an
we're not trying to
unintended
create a
consequence.
problem for the applicant either. We're trying to just resolve this as fairly and equitably as we can, so,
Yeah, but
yeah.
didn't he recommend that we should, if we're gonna grant a variance, we should make it, first thing is make it a buildable lot, or a recorded lot?
Yeah, and that's what we're doing, but as this standard with this area, those types of things, all this in that.
Okay.
Were there any other items that you thought of?
Anything else that you can suggest?
I think that's
Looking at the dimensional standards of the currently, nothing else is jumping off. I think with those variances you have mentioned, they would be able to record that lot, which would allow them to move forward in the development process.
And we were still willing to do the condition about the 30% lot coverage applying to the building envelope, not the full 40,000. You can leave it if you want to, but if you want to
I
do
think it
that
makes
condition-
sense to do it because it covers the zoning piece. I kind of almost want to chop the bottom off, like it's not there, it's yours. You're welcome to walk about and enjoy the space, but that's it.
And the only question,
Not something, Bill, you know.
Nothing goes over there. You don't build anything over there. You might set one up for the day, but you don't build anything over there. Right.
So from an order perspective, I think if everyone's okay, I think the cleanest way to do this is that these are variances being granted from the current
envelope and not the
ordinance
entire lot.
standard.
Yes, that makes more sense.
And then you will then
This is more
record, and then that way it's clear
Yes.
that
Yep.
development and everything is under the current ordinance. Okay. As long as we're on the same page, that's all I need to know.
I agree with that, that's fine.
And the lot coverage percentage is 30%, is that right, for single family?
Yep.
Yes, that's correct.
Okay, and that would be, the condition that you guys are agreeing to is 30% lot coverage of the,
18,641 square feet.
Yep.
Okay.
And we can, what we can do is have Mr. Barr prepare another plat that we can take the little red part off at the bottom and then clear this all up and say it's open space, in that triangle, and restrict it to that, and then also put notes about the lot coverage is measured from that 18,000.
Or
And,
maybe
the access-
undevelopable
Spell
area.
out all of these conditions on the plat itself, and then y'all can direct that it be recorded, and then we'll record that plat after the order's entered.
Mr. Kemp, one more question to clarify too. The south of the 110-foot width mark being open space, do we need to clarify that in any other language such that no development goes on in that area ever?
No, I think that, just something as simple as no development of any kind, or, no structures or development of any kind shall be located south of that. I think that covers, any kind of permanent thing, and it would allow them to set up a volleyball for the day or, that sort of thing. I think,
Yeah.
I think structures covers that in our ordinance.
Right, yeah.
And they did suggest that they would agree to put that in as a restrictive covenant within a deed, a transfer. I mean, how else are you gonna put the next person on notice?
If it's on the plat,
Okay, you're gonna put it on the plat?
yeah, I think we put it on the
Make sure
plat
it's noted in
and
the
reference that it's due to a variance, and then, that is what it is. I mean, we can do a restrictive covenant if you wanted to, but it's probably overkill.
Do you agree with that, Mr. Kemp?
Yes, as long as the map is
I do.
referenced on the deed.
I do, because the plat, when there's a transfer, as Sam said, it wasn't always this way, but now, that plat, when there is a land transfer, will be referenced. If it is on that plat, that's a legal document, that would be sufficient, in my opinion.
Thank you. So the 5 changes, taking this,
You want to read them back?
It's like
yeah,
every-
I want to just make sure we got everything and everybody's on the same page. Mr. Kemp, if you disagree with anything we're saying, please interrupt.
And applicant as well, if there's.
Yeah, if there's something that we didn't do that was fair in this as well.
And I just want to
Okay.
make sure that your microphone is on so that we can listen to it on video to make sure we get it right when we do the plat.
It should be. I can hear
I
it.
think I can hear you, but I
So,
just want to make
okay.
sure. I go to these meetings all the time, and sometimes they are, sometimes they aren't.
Maybe 7.
We're not gonna do a bait and
All right.
switch on you then, okay?
Oh, I'm not worried
All
about
right.
that. I just got to type it up.
The 5 that I counted, number 1, changing the western setback to 25 feet. Number 2, access from Sandpiper Road.
Right.
Number 3, south of the 110-foot width line, to be labeled open space, no structure or any development. Number 4, 30% lot coverage, which applies to the 18,641 square foot building area. Number 5, prepare this with Mr. Barr with these changes, and after approval, record with a variance included to the minimum lot size being accepted as 41,876 square feet. I may have combined two there. Basically, one being, we're doing a variance to the minimum lot size of 41,876, and then we will record this once approved
Right, with the Office of the Registrar.
with the Office of the Register of Deeds. Did I miss anything?
Nope.
Maybe we should put another stipulation that the plat map must be referenced on the deed
So
once it's been changed.
I was gonna suggest that number 6, which we kind of work back to, that the sixth condition be that the applicant provide a new plat referencing the conditions, to, be recorded and shall be referenced in any deed.
Any deeds.
Transfer, and then that way that condition's kind of there, and that way it'll come back that way.
Right.
That way everybody else in the future knows about it.
Correct, and it can be on both those, so Mr. Whoever, someone needs to provide Mr. Barr.
Would you like us to have a motion including that? Or go through the motion process about what Sam just said?
Should we do the points?
You mean about that last point?
No, about the
six.
entire
Entirety.
amount that we
I
just
can
said.
do all 6, I think you guys are all in.
So the 5 changes, taking this,
You want to read them back?
It's like
yeah, I want to just make sure we got everything and everybody's on the same page. Mr. Kemp, if you disagree with anything we're saying, please interrupt.
Applicant as well, if there's.
Yeah, if there's something that we didn't do that was fair in this as well.
And I just want to
Okay.
make sure that your microphone is on so that we can listen to it on video to make sure we get it right when we do the plat.
It should be. I can
I
hear
think
it.
I can hear you, but I
So,
just want to make
okay.
sure. I go to these meetings all the time, and sometimes they are, sometimes they aren't.
Maybe 7.
We're not gonna do a bait and
All right.
switch on you then, okay?
Oh, I'm not worried
All
about
right.
that. I just got to type it up.
The 5 that I counted, number 1, changing the western setback to 25 feet. Number 2, access from Sandpiper Road.
Right.
Number 3, south of the 110-foot width line, to be labeled open space, no structure or any development. Number 4, 30% lot coverage, which applies to the 18,641 square foot building area. Number 5, prepare this with Mr. Barr with these changes, and after approval, record with a variance included to the minimum lot size being accepted as 41,876 square feet. I may have combined two there. Basically, one being, we're doing a variance to the minimum lot size of 41,876, and then we will record this once approved
Right, with the Office of the Registrar.
with the Office of the Register of Deeds. Did I miss anything?
Nope.
Maybe we should put another stipulation that the plat map must be referenced on the deed
So
once it's been changed.
I was gonna suggest that number 6, which we kind of work back to, that the sixth condition be that the applicant provide a new plat referencing the conditions, to, be recorded and shall be referenced in any deed.
Any deeds.
Transfer, and then that way that condition's kind of there, and that way it'll come back that way.
Right.
That way everybody else in the future knows about it.
Correct, and it can be on both those, so Mr. Whoever, someone needs to provide Mr. Barr.
Would you like us to have a motion including that? Or go through the motion process about what Sam just said?
Should we do the points?
You mean about that last point?
No, about the
six.
entire
The
amount
entirety.
that we
I think
just
we
said.
do all six. I think if you guys are all in, unless somebody are not in agreement about that. I mean, these are not legal standard. I think we've discussed the conditions well. I think you can do them in one
Okay.
global.
Okay,
Do you want to do that, Sam?
I can do that. Make a motion to approve the 6 standards that we've prescribed relative to using this plat.
Second.
I'll second.
And
Well,
would you like to amend it referencing what you just said
Can I,
about those conditions?
and can you add just to grant the variance? I mean, that would be the motion. You've gone through the process for each of the things, so that normally if you didn't have conditions, you would make a motion to grant the variance. So if you could just add that to the granting it with the conditions you came up with.
Let me redo this motion.
I'm sorry.
All right, I make a motion to accept, or excuse me, I make a motion to approve the variance with the 6 conditions that we have discussed and agreed to, with the help of the applicant as well as staff. Do I have a second?
I'll second that motion.
Yep. All those in favor say aye.
Aye.
All opposed, nay. Motion passes unanimously. All right, are there any announcements whatsoever tonight? Hearing none, can I have a motion to adjourn?
Like to make a motion to adjourn?
I'll second the motion. All in favor, say aye.
Aye.
All opposed, nay. The motion carries unanimously. We are now adjourned.
Thank you all for spending the time with us tonight. We appreciate it.
On behalf of my wife Tara and I, you had said nobody else is watching. She's at home in Florida,
Oh, yeah.
watching it on video.
Yes, sir. We definitely try to be thorough.
Yes, sir.
So you got to head back to Florida.
Yeah. I don't care what anyone says, what we do is very important, and it has to be done right, because for so long, it's been done wrong. Even if, yeah.